episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to Surviving the Survivor. It is the show that brings you the very best guests in all of true crime on trending criminal cases. And this is a case that goes back to 2014. Of course, we're talking about the murder of Dan Markel, our OG story here at Surviving the Survivor, an FSU law professor. He went to Harvard undergrad. He is a rising legal scholar, gunned down in his Tallahassee driveway. You fast forward, and now two hitmen, a middle woman, Charlie Adelson himself, the ex-brother-in-law, all convicted of murder in this crime, except for Luis Rivera, who cut a plea deal, and Mama Donna Adelson, called her Donna Donaldson. I put it all together. She was set to go on trial this past fall, then this past week. It's all been continued, and today the defense is asking for a change of venue. Here are our best guests. You know them. Famed Tallahassee criminal defense attorney R, the letter R, and OUR, Timothy Jansen, also a former federal prosecutor, and the professor. She's not with Marianne or Gilligan, but she is the professor, Professor Emerita at the University of Nebraska. And here we go. This is the beginning of this motions hearing. You are looking at the Honorable Judge Stephen Everett, who, by the way, this defense has tried to kick off this case multiple times. Let's see how he reacts. Joe and Tim, we're going to watch this, and we will jump in. This is supposed to last up to 2.5 or 3 hours, and whether Donna testifies, we don't know. Judge Stephen Everett, he always comes prepared. Tim, it looks like he's looking at some stuff on the computer. So before he starts addressing the attorneys, what are you expecting here?
Well, I wrote an article for the Democrat. It didn't make the paper today, but they cite that it didn't make it. I don't know timing wise. They cited two cases: Sam Shepard, the doctor that allegedly killed his wife, and they decided the Utah case. Neither one of them fits the facts of this case. But I think their chances of a change of venue are premature, and that Florida law requires that they try to pick a jury. So,
Cappleman.
All right, let's take a listen here. Georgia's here. Georgia's in the house.
On behalf of Mrs. Adelson.
Joshua Zellman on behalf of Mrs. Adelson.
And I will note the defendant is present in the courtroom for the evidentiary hearing as well. Before we get started with taking the testimony of the witness, Mr. Murphy, I believe he's going to be the only witness for the defense today. Is that correct?
That's correct, Your Honor.
All right. In reviewing the motion, the affidavits in support, and also the memorandum of law, I wanted to make sure the state had not filed a formal response. You were planning to make your argument today. Is that correct?
That's correct, Your Honor.
Very well. As to the affidavits in support, Mr. Zellman in particular, I saw that you had placed an affidavit concerning this matter, specifically for the court to consider this as it goes to both being advocate and witness in the same matter. How exactly is that to take place?
Your Honor, the rule requires an affidavit of 3 individuals, one being the defendant and 2 other individuals. It does not identify who they are, and also does not require that those individuals testify.
Again, you are the primary counsel for your client, correct?
Yes, Your Honor.
So as to your legal arguments and also your factual affidavit in support of, you believe the court can properly take notice of both?
Yes, Your Honor.
Does the state have any argument concerning those?
No, sir.
Very well. As to whether there's any issue with court accepting that as evidence, I will conduct my own research, but we will move forward at this point. I do see Mr. Murphy is already in the Zoom. Mr. Murphy, good morning, sir. I think you're muted right now.
I only do this 10 times a day. Good morning, Your Honor. My apologies.
Good morning. Good to see you. The technology helps it be more convenient, but at the same time, well, at least you're not like the lawyer who was, I believe, on the Zoom saying I'm not cat.
The morning is young, so I'll try to avoid that.
We're doing much better in that regard. All right, I believe previously in preparing for the hearing today, the time allotted was going to be 2 hours to the defense to make their presentation. The state would have a half hour to respond. I will go ahead and swear in Mr. Murphy, and the defense's time will begin at that point. Mr. Murphy, please raise your right hand to be sworn, sir. Do you swear or affirm the testimony you're about to give today as a part of this proceeding will be the truth?
Yes, I do.
You may lower your hand. Mr. Zellman, you may examine the witness when you are ready.
Thank you, Your Honor. I have a number of exhibits that we discussed the other day on a flash drive. May I approach with that?
You may. This is a newer version of this binder.
Some of the information has been updated, yes, Your Honor.
Right. Is there any objection from the state as to the court considering this as admitted evidence for the defense for the hearing?
No, Your Honor.
The jump drive will be defense one. You may continue.
So the way that I have the drive organized, Your Honor, there are 6 folders. Exhibit 1, Exhibit 2, and Exhibit 3 are materials from TrueScope. Can I have permission to share my screen so that Mr. Murphy can?
You may.
Donna in an orange jumpsuit. Orange is the new orange.
So the Exhibit 1 is TrueScope's raw data that we had previously submitted. Exhibit 2 is the original report from TrueScope, and Exhibit 3 is the updated report that was finalized. We'll be going through those, and just by way of a brief opening, Your Honor, if I may.
Go ahead.
It goes without saying that the 6th and 14th Amendments to the United States Constitution, as well as Article 1, Sections 9, 16, and 22 of the Florida Constitution, guarantee an accused a fair trial by an impartial jury. With that, Your Honor, I guess you've already sworn Mr. Murphy. Mr. Murphy, can you please introduce yourself to the court?
Yes, my full name is James Todd Murphy. I'm president of TrueScope in North America, media intelligence and analysis service.
And what is media intelligence and analysis?
Media intelligence is the overall term given to our industry that includes media monitoring, media analysis. It's kind of 2 components to the single industry. Media monitoring is the action of tracking and indexing and reporting media across or stories from media of all types. And then media analysis, sometimes called insights, is the analysis of that data, looking at both qualitative and quantitative information, using a framework that is that can repeat valid results.
How does TrueScope gather that media?
We have 2 primary, or I would say two different methods. One is we use aggregators that pool content. So for like the broadcast data, we have a party that records all designated market areas, or those maybe simpler to think of those as cities. There's 210 city markets in the United States that are monitored. For example, New York City is number 1, and it's based on the size of the market area. So for TV and radio, we aggregate all that, and it comes to us in a feed that has metadata attached, so we know the date, time, station, and then the video is indexed to a timestamp. We do the same thing with radio, podcasts. On the print side, we actually scan much of that, although we do receive feeds from partners of scanned and indexed data. those generally are sent to us directly from the publishers as PDF images with the text layer behind it. So there's really no break in the chain coming from them for their printed media. We do the same thing with magazines. Social media, it's more of a feed from each social network. Facebook has a feed, Instagram has a feed, LinkedIn, etc. Online news, we use a system where a crawler crawls the web, pulls back anything that has changed, that then gets put into a feed. And these feeds all come into us via an API, which is basically just a conduit for communication. All that comes into our server or servers that are hosted on Amazon, where that data is then processed into topics, in additional supplemental metadata. Additional data is added to that. Who's named in here? What industries are mentioned? And all of that then is indexed so we can run queries against that and report just specific topics. So if Judge Everett wanted a report each morning, for example, of anybody talking about him, he would get, at whatever specified time, a report of all media, or if there's no media today, he would get a report saying there's no news about you. That's the media monitoring side. The media analysis side then takes all that data that we've captured for a specific topic, and we run some automated systems against that to generate media dashboards, charts, graphs. That's mostly for the quantitative side. Once the quantitative side has been developed, then we apply our methodology for the qualitative analysis. And stop me if I'm going too deep for this question.
No, this
Way
is
too
perfect.
deep. Get to the point.
Yeah, it's amazing how some people make money off of these businesses
Right.
monitoring media.
Methodology within our framework for the qualitative data, and that's currently based on the Barcelona principles, Barcelona 3.0 principles, as set out by the Global Measurement Association, trade association called AMEC, AMEC. So we use the AMEC principles to make sure that we're using best practices in evaluating the media that we've monitored.
Now, let's talk a little bit about your background and training. Can you tell the court about your background in media intelligence and analysis, please?
Without sounding, I guess maybe too folksy, my family has been in the industry since before I was born. My father purchased a press clipping service, as they were called, in the late 50s. I began broadcast monitoring when I was 15. He wanted to add the TV and radio side, so I technically set that up for him. And graduated from college in 1991, began full-time, and then developed additional services like competitive media analysis, qualitative media analysis, and others.
I knew this dude inherited this business. No one goes into this otherwise.
You got it from his dad?
Yep. Dad started in 1950s.
Film and a minor in psychology.
Beginning in 1991, can you advise the court exactly what it was that you developed through the company? And it wasn't called TrueScope back then, was it?
No, it was initially it was called Universal Press Clipping Bureau, founded in 1908. In 1998, I changed the company name to Universal Information Services, and then in January of 2023, I merged the company with a
Snake oil.
technology firm out of Australia by the name of TrueScope, taking on the name TrueScope.
Now you know why it's going to take 2 hours.
Yeah.
Or a little bit
Might be
further
5.
into the field of media intelligence and media analysis.
Sure. As you might imagine, a person who is born into it and
Pretty funny people.
grows up from a young age in it. I've held all the leadership roles in all of our trade associations. which includes IABM, which was the International Association of Broadcast Monitors, NDS, which was the News Data Services Cooperative, the NACPCS, National, it's a press clipping. It was an early press clipping conference. I can't remember the exact acronym right now, but it was a North American Conference of Press Clipping Services. There we go. My apologies, Your Honor.
North American Conference of Press Clipping Service. My God.
Became a member of AMEC to add the measurement side.
Can you imagine seeing his resume? It's probably 4 pages long.
Leadership roles there, and currently president of FEBEC, which is the global trade association over all MMO, the entire media monitoring organization industry, which constitutes both both media monitoring and media analysis companies.
Now, in addition to that, have you yourself also developed software that is now used in the industry?
Yeah, in the 90s, I had 2 primary developments. One, in 1995, developed the methodology for comparative media analysis, which was transparent, allowed you to see all the data behind the figures and the inferences, and allowed you to compare one entity against another. In the commercial realm, it might be a market, say Chicago, for example, that has a multitude of healthcare systems. It would allow one healthcare system to track how they're performing, both in terms of volume of media mentions, impact, reach, and then the qualitative side, primary message points where they either are leading or trailing their competitors. I also developed the first software and database and hardware solution that allow you to track multiple TV stations. The closed captioning that's embedded in broadcast programming. I had a program written where I could extract multiple channels, 4 channels simultaneously, all to a single database and that was the first instance of indexing broadcast media, which has come in handy when people try to trademark and patent that process. Having that prior art has helped me.
Have you previously testified as an expert in media intelligence and analysis?
I have.
Approximately how many times?
I think this will be my 5th.
5th.
His audio's bad because he's on his yacht in St. Bart's in the shame business.
Anyone know where he's located, where he lives?
Testimony.
No idea.
Similar to this would be my 5th time. Probably an equal number of our data plus an affidavit have been sufficient. If that's a fair answer.
Thank you. Your Honor, we would tender the witness as an expert in media intelligence and analysis.
The state wished to voir dire the witness.
No, Your Honor.
Court at this time will permit the witness to testify in the form of an opinion during this hearing as to the specific topics of, I believe it was media analysis and what was the other?
Intelligence.
And media
Intelligence.
You may continue.
Thank you. Now, in the field of media intelligence and media analysis, in addition to gathering this data, you also have to quantify that, and that requires math, correct?
Correct.
And the mathematical principles that you use are generally accepted in the field of media intelligence and media analysis, correct?
Yeah, that is correct.
And in addition to the math concerning that issue, is it also generally accepted in your field to use similar mathematical principles to identify how many times somebody would have to see something in order to form a memory, and there's a standard formula for that we're going to go over, correct?
That is correct.
Now, on a factual level, how closely have you followed the murder of Dan Markel in the state of Florida versus Donna Adelson?
I have not followed it at all. Personally, as a standard operating procedure, I tend to avoid news such as that on the principle that we may have a client that we serve in this capacity. Certainly once engaged by a client to evaluate a specific case, I will call it, I tune out completely and avoid all media related to it. Just on the outside chance, I might see something that subconsciously would influence my opinion. Now, anytime you frame something, for example, you're looking at me right now and you're forming an opinion about how I look, that's the principle I apply. If I were to see a television news story, it's through the lens of a reporter. Even if it's an unbiased story or what we might call a balanced story, it's still framed, and what's in the frame, or what they might call the mise en scène, things in the frame can also influence. So as a person in my capacity, I avoid specifics related to a case we have, if not before.
Now, how has TrueScope collected the data in this case?
So in this case, all of the data has been gathered through our standard operating procedure through our aggregate systems, transmitted via API calls into our servers for indexing, processing. The text is never modified. The data that we receive from the media outlet is never modified. It's simply categorized and basically labeled so it can be recalled and have additional information telling us who, what, where, when, why, what time, that type of information. That, go ahead.
No, please.
And then that information for a client or a case such as this is analyzed and managed by my media analysis team under the direction of Cheryl Lewis.
And the way in which the data was gathered in this case followed the generally accepted methodology in your view?
Yes. So one of the things, we have 2 layers of check and balances above each of our departments. Jean Saucier, who oversees, she's my senior vice president, oversees that department. She checks to make sure that progress towards a timeline is being made, but also that each step in the process is followed. Within the media measurement team, they have 2 people, and we have a rule that 2 sets of eyes look at everything. So anytime a spreadsheet is created, the assistant media analysis.
So Joel, this expert was used in the Idaho case also, but that venue was changed for different reasons.
Different reasons, yep.
For a small town, they couldn't, so that's how they found this guy.
Okay.
Mr. Zellman, is I review all the data with the team, and I ask for additional things that I want to see. It could be volume of mentions over time or something else. So I don't look at the data prior to the nearly final reports, and then I say, okay, is there something missing in this situation? And ask for them to produce that.
Now, in doing so, you talked about a spreadsheet earlier. TrueScope prepared a spreadsheet of the raw data in this case, correct?
Yes.
I wonder how much he got paid.
Spoken by a defense lawyer who gets paid by private clients.
Well, I don't have to detail how much I get paid. I'm not a witness.
I'm looking up TrueScope, and I see it based in like Australia and New Zealand, but it does the same thing. This is
I
weird.
thought I found it when I looked a while ago. Wait a minute, let me see.
The different tabs, generally speaking, or simply put, correlate to what queries resulted in the data found. So for example, this first tab that you're currently showing will be a query for either Donna Adelson or Charlie Adelson, potentially would include any variations on the name that would then be reviewed to make sure it's the correct Charlie or Donna Adelson. Each row on the spreadsheet then
Headquarters is New Zealand. But what I find says their office is in Omaha, Nebraska and New York.
Interesting.
A TV story or.
But I don't see this guy listed as the founder or CEO.
So you're going to see all the metadata that is included with each story.
And can you tell the court how many articles, and this appears to be newspapers?
Yes.
How many different mentions were found? And what was the time period?
That's what I was going to ask.
So we looked at a couple of different slices. Some of it came back further than others to do some comparative analysis, I know. But overall, I believe we went as far back as 2014 to 2025 for some of the data. And then we also did a June 2023 to May 2024 sample analysis.
And so
I'm not sure that answers your question directly, though.
With the newspapers, this tab indicates there were 233 mentions of Donna or Charlie Adelson during that time period, correct?
That's not very many.
Yeah, that's exactly correct. 233 rows, but the first row would be headers.
And then can you tell the court what this second tab is?
That would be another query, a new query. That's not looking specifically for either Donna or Charlie Adelson, but additional names associated with this case that you or the client would ask us to look at either for comparison purposes or whatever they need. We generally don't offer legal advice on what you need for your situation, but the advice we give is how we've done this in the past and our expertise in doing it in the past, and we would suggest, are there additional people involved in a subject that should also be queried to see how many stories mentioned them and in what relation to the overall subject you're most interested in.
So with respect to this tab, the searches were done for the alleged co-defendants or co-conspirators, McDaniel, Garcia, or Rivera, correct?
Correct, and although we just have last names listed, again, we would have ensured that we were using first names and variations that correlate directly to those individuals.
Wow.
And for this tab, there were 308 mentions of those of the alleged co-conspirators, correct?
That is correct.
Are they going to tell us how many of these two categories overlap?
That's going to be more of a, I'd call it a specific media type analysis. So it's a media type within a specific name query. So in this case, we were looking at queries of Dan Markel, or a search term of Dan Markel, in both broadcast and some web content.
Okay. Now, the dates in the first column, the formatting is a little off, but what does that represent?
That would be the date. That would be the date of broadcast So in that first, or what is designated as row 2, that story aired on January 8th, 2014 at 5:34 p.m.
Was it January or was it August?
Oh, thank you. Because our technology is built in Australia, our dates are
Reversed.
day, month, year,
Right.
as opposed to
Month, day.
month, day, year, as is more commonly used in the United States. We provide this service on a global scale, so even I have to remember that. My apologies.
Now, in this tab of information, does this include closed captioning from television newscasts or broadcasts?
It does, that's correct. So that's text inputted or live captioned by the broadcasting station or network.
And this also includes the link to that raw data, correct?
Correct.
And
It would be nice if they'd put that on a monitor so we all could see it.
mentions or
Yeah. This is going to be kind of humorous when Georgia gets to her.
2,818.
and then what does this next tab represent?
So this is going to be what we call internally the roll-up of the quantitative data related to different views. So in this case, we're looking at cities or potential designated market areas. We include what county they reside in, and then we calculate and the system tabulates the exact amount that each of those cities and or counties, how much the volume of media mentions. So that would be the number of stories or articles or web pages within that geographic area. Column D would indicate the total audience. People may be more familiar with the Nielsen ratings. That's where those audience figures come from. Sometimes you'll see them referred to as impressions. That often is a more generic term that can apply to other media types. But in terms of broadcast, that would be the Nielsen audience rating based on their methodology and their standard for establishing how many people had an opportunity to view that story in a specific geographic region.
And so would it be accurate to say that your team looked at the total amount of articles and broadcasts that were identified in the previous tabs and then sorted them based on market area?
That is correct.
And the total number of broadcasts or articles that were published and TrueScope was able to collect, what was the total for Leon County?
2,371.
And then where did you get the total number of adults in Leon County from?
That would be from the most recent census numbers from the government. So that's the, obviously, census.gov has that data. We use that data to pull the most accurate count as each census is updated.
And can you explain to the court
Checking his phone.
What opportunity or to be seen or impressions per person represents?
Sure. So whether it's a tabulated audience or unique visitors to a website, each media type has their own type of audience count calculation or impressions. Since the simple math takes the total number of stories and then divides that into the population of an area that we're looking at. So you take column C and column E, and you can come up with, including column D, you can come up with a calculation just on basic math, where on average, an individual residing in that geographic area would have X number of opportunities to see this specific story, whether it's hurricanes or a story about a hurricane or the subjects within this case.
Before you continue, Mr. Zellman, I do have a question on that point. Mr. Murphy, is the opportunity to be seen the same thing as definitive proof of engaging with that particular content?
It can't be, engagement can't be measured in what I call the passive mediums. That's going to be television, radio, because you might turn on a radio station in your car and listen to the news on your way to work, but I can't say that you necessarily engaged with every story. You may be a sports person and you're just waiting for them to get through the weather. So opportunities to be seen is I'll call it a more objective label to put on it when the media is passive. When it's an active medium like social media, we do have the ability to calculate engagements, like if you liked it, if you shared it, if you commented. So we do use the more objective opportunities to be seen to calculate the potential of an average adult or jury eligible individual within that geographic area to see a story.
Please continue.
Thank you, Your Honor. Now, in addition to conducting this analysis for Leon County, did you look at other counties in Florida?
We did.
And we're going to go through that in the next exhibit in more detail.
What relevance does that have?
That's what I was going to say.
Pull up.
And doesn't a census count for students? Don't they typically list their permanent home residence rather than the city they happen to be in when they're going to school?
Yeah, and you know what? The other thing is most of them register here to vote because the elections are while they're in school.
Right,
So
but
they will
that
probably
would be
register voters, and they won't
Yeah.
make the census. Yeah.
Yeah. So they're undercounting the adults in Leon County because you've got what, 3 universities?
Yeah. What number did he say? That's like 296,000 in
But he
Tallahassee.
said there
hear-
was 2,371 media. I guess it's art. He called them articles, but I don't know what that entails. That had been, I guess, published in is that the entire time since 2014? I'm not sure.
No, and the time is important.
Yeah.
He said they didn't have one specific time. They used sometimes to compare. And I wrote some of the dates down. They weren't the whole time, at least not the way I heard it.
Okay. Yeah, that's important.
And they didn't tell me about overcounts. If you count mentions and you count Donna and Charlie, the chances are that in a lot of those stories, all 3 are going to be mentioned at the same time, and they're going to double or triple count, as I understood what he said.
This is the media coverage for nearly an 11-year period by county, from designated counties in Florida.
What counties, so Leon County, this is the 376 opportunities to be seen, potential impressions that we discussed previously. What other counties did you focus on, and we'll get to that next exhibit.
Oh, I'll bet he's going to use it for change of venue, that there were fewer counts and fewer looks in some of the other counties.
Yeah, they're not getting a change of venue. This is all for a record.
I know. But what he's doing with the other counties would be relevant in making the case that
Right.
there's a lot of attention in Leon, but not so much in some of the other counties. That would be the only relevance I can think of.
It'd be nice
Yeah.
if Zellman would move that mic at least somewhat
Yeah.
close to his mouth.
That we're analyzing for the client to see which media types were most predominant. This often comes into consideration when I'm
Yes.
looking at active versus passive media types. It can also be used to make inferences. based
COE
on
or Space Coast, can we pump the audio a little?
versus media
Yeah, it's hard to hear Murphy. At least I'm having trouble.
Yeah.
just to elaborate, believe it or not, despite what we often see in political rhetoric, there are journalistic.
Is he dipping? Because he doesn't hold it up high enough to drink. Is he dipping?
I don't. I thought it was
I don't
an
know what
inhaler
dipping
at
is.
first.
Well, I mean,
What's dipping?
Chewing tobacco.
chewing
Oh, okay.
tobacco. I don't think holding it up high enough to drink.
It's his.
I'll look this time. I wasn't
Okay.
watching.
It's his spit Stanley. He spits.
Oh,
his
gee.
It just
I'm
tobacco.
gives
sorry I
me
asked.
a spittoon. I'm so bored. I'm watching this guy dip.
What is the purpose?
Talking to the mic, Zellman.
He's dipping. He can't talk.
That is what I would call more of a control analysis, a simple control analysis to look at what would an average news story in the same area generate in terms of, say, impressions, or we look at several factors, total volume, how long it takes for that story to decay. Invariably, what it's going to show you is the attention, and the judge previously asked about engagement. There's a certain level of desensitization to the stories that are most common: car crashes, fires, things that we commonly see every day on the news. But we like to often look at what a average or common story statistically looks like compared to the story we're looking at for our client.
And so with this car crash story, how many opportunities do we see in our impressions? Trying to get to the right slide. Did you calculate for the average story?
Well, I'm having a hard time reading that. It's going to be the number of stories divided by the population, but I can't quite read what, I don't want to confirm what you're all seeing versus what I'm seeing.
Let me see if I can zoom in.
No, it's like trying to pass the vision test at the Department of Safety Motor Vehicle.
Your Honor, I failed the vision test. I was just kidding. That's not true. For the record.
You have to explain that you're kidding. It's not a good joke.
Yeah.
Is that better?
Look at
Yes.
Fulford. This audio's, they're not talking
Bad.
into the mics. Yeah. So this is
Yeah.
Spacey's trying to work with what he has, but
Average story appeared in the media about the car crash. Let's see, six stories were reported on that
YouTuber
topic.
says my article's in the Democrat, but I didn't see it. I compared the Idaho case to Leon
Mhm.
County.
It's different.
Completely different. And that
So is
town,
the Shepherd case, the other one.
Shepherd was all
Totally
about the
different.
conduct that happened
In the
during the
courtroom.
trial.
I know. Totally different.
by the way, selfishly, this might be my favorite comment. You guys rock, P.S. Joel. I'm a gay chick, but you have the best sexual. Thank you, Mary. I love you, Mary. You made my day, Mary.
Good thing Monica's not here.
Yeah.
Jury
Yeah.
eligible residents had 6 opportunities.
This is getting worse. It seems like he's whispering more.
It's his chew. It's his
Yeah.
tobacco.
It's Murphy.
Yeah, they're
And finally,
Well, it's a combination.
So far, am I right? What they do is count hits,
Right.
yeah, there's a lot
and
of
then
these
they try to
companies actually.
analyze it. Yeah.
Yeah, there's a lot. Yeah, and this guy's entire job just got a million times easier with ChatGPT.
Mm-hmm.
versus how many county?
Just under 160,000.
Before you continue, when you say census data, this is the 2020 census number that you're using as a part of
It
your.
would be the most recent census data.
Please continue.
By the way, now we'll stop talking. But Sigfredo Garcia was moved from one prison to another that's much closer to Tallahassee. FYI.
Right.
Bigger for you.
Yeah. One of the comments was, do we think this has a shot? I think it has 0 shot of a change of venue. The law requires that you try to pick a jury. And I think that they need to try to pick a jury, and they've been able to do it in 5 trials.
Right.
And it's been over 2 years since the
Right.
last jury selection.
And so far, I haven't heard them talk about in their analysis. They talked about how memory develops, but they didn't talk about how long memory sticks.
A quantitative count of stories over time. This is generally helpful in seeing the peaks and valleys. We can also easily interpret the decay of a story. So moving from left to right, in 2014, we see there's an additional starting point of the data, which then decays over the year to a low in 2015, and then spikes again during the year of 2016.
Oh, my article did make it.
Correlate those spikes to activity around the subject. In a case like this, it can be.
Since you're bored, Joe, I'll send you my article.
I'd like to read it. I'm wondering about the choice of language. Decays rather than the hits decrease.
Almost invariably,
I hate this kind of jargon.
Some activity
Yeah.
around the specific topic. And then on the right side, you can see between the years of 2021 and 2025, a more rounded, but increasing volume of media coverage on this topic, which would indicate there are more things happening of interest to the media, and a slower decay where follow-up stories are occurring during that date range.
What does this next slide represent?
That's going to represent the impressions of the media. I'm sorry, the impressions the media are generating for that same time period. The scales are going to be different, so the peaks are still there, and so you can see the 2016 and the 2019 peaks, and then you also see that kind of 2021 things start moving up, and then that more rounded curve from the prior slide, you can see how it's represented by the impressions of the media covering that subject. How many people it's potentially reaching?
Okay, and according to the analysis that TrueScope has conducted, can you tell the court what 2025 is 2025 projected to be higher or lower than 2024?
Yes. Impressions from media coverage for 2025 are on track at this point to surpass 2024.
what do we have here in slide 4?
So this would be another control comparison, impressions of volume of coverage to another recent change of venue hearing or case based on what data is currently publicly available. So it indicates media exposure within Idaho compared to Florida. And what it is specifically is a heat map of each state showing the density of media coverage in various counties.
And with, and so this is what time frame was this analysis done here?
This was just a 1-year sample where we had overlapping data collected. Since we also did this work, this is overlapping data using the same methodology and framework from a case in Idaho, where we also had the same type of overlapping data from the Florida case.
What is represented in this slide?
That's going to be the same date range comparing 2 counties in Florida. The blue line would be volume of stories in Leon County versus volume of stories in Miami-Dade.
And how many, what was the volume of story? And again, it's that same 1-year time frame, June of 23 to May of 24. What's the volume of stories in Leon County?
283.
And what was the volume of stories in Miami-Dade County?
It was about 6.
What happened?
I'm not sure. Stand by. I'm sure Space Coast is working some magic here. So,
So what they're doing is output, not input.
It's going to be similar date range.
I don't think they can do input. Unless
Well,
you did
but you know,
survey.
But showing the impressions,
yeah.
the total tally of audience. And it's showing that in blue, Leon County
Input is selecting the jury.
had more impressions within that geographic area versus the number of impressions in the Miami-Dade geographic area.
What does this next slide represent?
Again, this is going to be a media type donut graph of volume of coverage by media type, which is going to indicate for me passive and active media, but also to anyone who's viewing it reveals which media was more engaged or reported more frequently on this topic.
I want to go back. Now, over the lifespan of this investigation, July of 2014 to present, based on your analysis, do you have an opinion on how the span of time has impacted the media coverage in the case?
Yeah, I can certainly provide my opinion. In my experience, it shows a topic of interest to the media where the story has what, has, you may have heard the phrase, the story has legs. It has captured the interest of the media over time. Some stories, such as a car crash, at this point in time, it would be nearly impossible to find anyone in the county where a car crash occurred that could remember any details of that story. This is indicating repetition over time, and volume of impressions are over time are high. So what I would start thinking is I expect to see in the numbers a higher level of retention based on saturation of an average citizen in a geographic area. So this is, in my work, this is what I start looking at and building what my expectation should be coming in the downstream data. And if I don't see it, then I have them rerun it to see if we made a mistake anywhere, or if there's a contributing factor to why a story stopped. But this is to summarize, this is a very typical shape and volume of impressions for a story that captures the interest of the media over time at a high level too.
And so I think that's a good segue into the math of memory that we discussed.
Oh, God.
earlier.
Math and memory.
Can you explain to the corp the concept of math of memory?
I hope everyone's had their coffee. So the math of memory is a basic probability theory that also uses a level of algebra, and it shows the ability to retain information, or inversely, how rapidly your memory of an incident or a story, in this case, decays over time. Ultimately, this formula is going to it shows, it's proven, and it's a globally accepted theory that it has repeatable and valid results. The more a person is estimated to be exposed to a story, the longer they'll retain up to 80% of the details of a story.
The person you're referring to with this is someone of average intellect with no defects.
Right. Again, it's when we say jury eligible population, that doesn't account for anyone who might be exempted for a reason other than age.
Of memory. And I'm sorry, Mr. Murphy, were you done with the initial explanation of the concept of math of memory?
Yes.
Okay. And so how does, when you have, number of impressions and opportunities to be seen, how does that factor into the ability of somebody to retain that information?
In my mind, it's fascinating how logarithmically your potential to retain information goes up once you surpass seeing the story just a couple of times. So what we do is we apply the number of, so we take the total number of media mentions or articles or stories, the coverage, divided into the jury eligible pool to derive the total number of opportunities for this story to be seen by a jury eligible person in that county. Then we can put that number into this formula and estimate statistically, I might say, I need to preface that with statistically, how long the average person of average intellect could retain up to 80% of detail on a story. How many, in terms of years?
Okay, and based on training experience, and when somebody has 376 opportunities to to see an article or broadcast or podcast, how long do they retain that information?
If it's 336 exposures, I can't even estimate. I'd have to run the math again. And I can tell you, for example, if a person's exposed once, that retention to interpret the story would be 3.3 minutes. And I've provided, I think you have that chart up as I provided it. You can see how it extends once you get up above 10. Statistically, it exceeds the lifetime of a human.
So breaking this down, with the opportunities to be seen that we have in this case, for an individual jury eligible of average intellect, they're going to be able to retain that information for their entire life.
Yes. And that's based on the resultant figure that in Leon County, the average jury eligible person was exposed 26 times.
But he doesn't mean jury eligible, does he? He's doing the whole population of
Yeah.
adults.
Yeah, right.
And that's not how is it just voter registration, Tim, that they use?
Voter registration.
So that's that then you can get those numbers. That's the number he should be working off.
Yeah, it's not like
It's like those
it doesn't
pollsters.
correlate.
Yeah, it's like those pollsters in elections where they test, they interview or they get numbers on the entire population rather than likely voters. The differences are dramatic in
Yeah.
the results.
Here's Fulford talking to Zellman. Donna looks like she's trying to stay awake.
Well, I know what I would ask him on cross. Isn't finding out whether people actually watched or read better data? I assume he'd have to say yes. And then I'd ask him about jury selection. Isn't that
Someone had
what
someone
jury
had a
selection is?
Yeah.
Excuse me.
Someone said Georgia should ask, does it monitor bias? And that should be the question.
That's another question, but I mean, I think even before you get there, it's the inputs that matter. I mean, they're
Mr. Murphy,
measuring.
Going back to the data that you were able to collect, you had mentioned earlier that TrueScope has the ability to collect and analyze podcast information and social media. Were you able to do that in this case?
To my knowledge, no, we were not able to include podcasts specifically in this analysis.
And why? And can you tell the court why that is?
There's two functional reasons. One, having access to the podcasts and retaining that data, we need to have a client engaged. If we don't have a client engaged, we're generally, let me start over. When we engage a client, we're tracking and going forward in those cases. With some media types, we retain that content and we can do back searching. In the case of podcasts, it's a newer medium. We don't have the ability to do back searching into the same time frame with podcast. So I believe that was at least one reason why we excluded it from the data.
And what about social media? Were you able to include looking backwards at social media?
Similar situation. Social media requires that we register topics, and that's an internal phase where we, in a sense, put the topic into the social network of, let's say, Instagram, for example, so that it can return results related to that topic through the API that connects us. Since we didn't have the engagement with your law firm in 2011, none of that had been registered, so we statistically excluded that media type. One reason. That would be my primary reason.
Just a moment, Your Honor. So, Mr. Murphy, since TrueScope was not able, TrueScope in this case was retained in January of 2025, correct?
Correct.
And so what you're saying about the social media and podcasts is because you weren't retained, you weren't able to go back in time to collect the data from social media and podcasts.
That is correct. Go ahead. I'm sorry.
If you had been able to obtain that information, do you have, are you able to offer an opinion as to how that would have impacted your conclusions about total number of potential impressions, or as the court was asking earlier about active engagement?
Yeah, so there's a couple specific, I would say, factual opinions I can share. One, neither of those media types are able to be geographically pinned down. A podcast can occur anywhere, but be specific to another region. So it makes assigning it to a geographic region nearly impossible in most cases. So that's one reason. And I apologize. Can you repeat the question, because I got too deep into my first answer.
So I was asking how, if you could offer any conclusions as to how, if you'd been able to obtain that information, how it would factor into your ultimate conclusions.
So the geographic issue is one. What it would have done is it would have simply increased the volume across the board. It would have been treated more like national media exposure. And let's just use a simple number of 100. Let's say if there were 100 podcasts, it has equal potential to be seen in any of these counties or heard, as the case may be. And social media is the same way. It would have an equal opportunity to be seen in any county, not in Florida, but globally. So statistically, it would simply increase the values across the board by the same number. You would apply an N factor to it, and it wouldn't change the charting of impact or opportunities to be seen. It would increase the opportunities to be seen in each county, but by an equal amount. So the outcome wouldn't change, if that makes sense. And I can rephrase that if it was confusing.
I understood what you meant. I don't know if the judge would like a different explanation.
Make it as simple as possible.
Can you?
The water would rise equally in every county, and so it would provide no one an additional bump or decrease over another. It would just be a wash.
So in other words, if you had been able to factor in the data from podcasts and social media, the numbers, whatever that number is, would have applied equally for Leon County and Miami-Dade County.
Right. It wouldn't change the outcome of the analysis.
They're not getting Miami.
Increase the numbers for all of them equally.
If they think they're moving this trial to South Florida, he has to get his head examined.
They're not even going to Wakulla.
I think so, Judge.
I think
Mr. Murphy, can you explain your fee schedule associated with your work on this case?
Here we go.
I would have to check with my accounting.
He has to check. He hasn't come prepared.
He's made so much.
I can speak generally to our fee schedule. There's a monthly subscription cost for us to monitor the data. And then in addition to that, if a client takes the opportunity to have us analyze their data, there's an additional fee for media analysis.
So
in
what
this
did they
case,
do
there would
for
be
the-
two
for this?
components, the media monitoring and the media analysis. And then on top of that, if myself or one of our team members is asked to provide testimony like this, there's an additional fee for my time or Cheryl's time.
Okay, can you give us a ballpark for what the cost would be for work that you've, like what you've done so far on this case?
Sure, a normal subscription to a monthly subscription of this type, and if I'm charging the client more, I hope that's not the case. But it generally runs around $1,500 a month for media monitoring. Analysis can often add another $1,000 or $1,500 a month to that cost. And then my fee, if I'm in person on site, it includes travel expenses, and then if it's just a one-day engagement, $10,000. If it's a virtual situation like this, my fee is $4,000.
So he's saying 2,500 plus 4,000?
So
Know
valuable,
how many
10,000 in
potential
person.
Jurors have actually viewed content related to this case.
Here we go.
No one can know that number for certain. So I think what we're looking at is possibility. Your question revolves around possibility versus probability. We're working with probability and statistics. When you want to say, I'm sorry, I answered your question. I won't go further until you ask me.
Oh, God.
So the answer is no, we don't know how many potential jurors have actually
Thank
viewed.
you.
We're basing it on averages and probabilities.
Correct.
Okay.
Correct.
And so is there a way that we could find out if an individual potential juror had viewed content related to this case?
There you go.
I believe that's part of what would be done in the jury selection.
There you go.
There we
We
go.
also ask the
Jury
juror,
selection.
I
how
get it.
long did you view the item? How much of it did you retain? Questions like that could be asked at jury selection. Is that right?
Yeah, any questions could be asked. Then we get into the psychology, the behavioral psychology side from my perspective. What's the probability? And in my case, I'll only be speaking to probability because space junk can fall on the courthouse and change everything. So I don't deal in possibilities, but the probability is what we presented in the numbers. I'll leave it at that.
So what did he say?
Do you have any data or probabilities about what percentage of potential jurors have formed a fixed or definite opinion about the guilt or innocence
go.
of this
That's another one.
defendant?
This is
No.
exactly
That's
exactly
a
the question.
complex question, which I do
Complex.
not have.
That's funny.
In your affidavit that you provided to the court in this case, 3 prior hearings were cited. I know you said
Yep.
4 previous hearings you've testified in, I think. Is that right?
Including this one.
Okay. So 3 prior, and how many of those hearings was the change of venue granted?
In the 2 earliest ones, those, I believe, one was moved from Sarpy County to Douglas County. That was in the
Nebraska.
90s, I believe. I don't believe, I think so, different circumstances impacted, I'll call it the boyfriend-girlfriend murder. I think, I believe the evidence was overwhelming and a deal was made before it went to trial or something. So I'd have to look back on that. In the most recent case, which is just about 10 months ago, that venue was changed.
So in the Catanacci murder cited in paragraph 14 of the defendant's motion, that case resulted in a plea, right?
That's my recollection. I don't have that information in front of me at
Right.
this point.
So that venue motion was not ruled upon because the case resolved. Does that sound right?
That's my recollection.
Okay, and in Nebraska v. Christopher Edwards, cited in paragraph 15 of the defendant's motion, that motion for venue change was actually denied. Isn't that correct?
That is correct.
Okay, and so we're just dealing with the Idaho case. Is that the case that we're probably all familiar with, where 4 college students were slain back in 2022, I think?
Yeah, that's
You're wrong about
the most recent one. But there's a little bit of an apples to oranges in the one where the venue wasn't changed. I was only asked to present on a report of media coverage. It wasn't a statistical analysis like this at this depth.
Okay, and in the Idaho case where the venue was changed, is that the same jurisdiction that's mentioned in your data compared to the data you prepared in our case?
I apologize, I didn't quite understand the question.
When we see the map of Idaho in the exhibits that we just reviewed, is that referring to that case that occurred in Moscow, Idaho at the University of Idaho?
That is correct.
Okay, and in that case, the judge did change the venue to Boise, correct?
Correct, Ada County.
And would you agree that the population in that county of Idaho where the case occurred was significantly smaller than the population we have here in Tallahassee?
That is correct.
Okay,
Yeah.
and in fact,
I mean,
in the motion that the
seven times
court
smaller.
granted the venue change, in that case, the court cited insufficient space in the courthouse,
There you
insufficient
go.
staff, and insufficient security.
This is outside
One
the
moment.
scope.
May I finish my question before there's an objection, Judge?
Please finish your question.
In that case, isn't it true that the judge, in granting the motion for the venue change, cited insufficient space in the courthouse, insufficient staff, and insufficient security, AKA deputies, to accommodate the trial of that case?
What is your objection?
Outside the scope.
It's in
I
his
believe part of his
affidavit,
testimony
Judge.
has been concerning his work in Idaho, is it not?
It
Yes,
did.
Your Honor, but we did not get into whether or not the venue motion in that case had been granted or the reasons for that in his testimony or in his affidavit.
But they tried
As
to.
to the subject matter, I will permit the question. If you are capable of answering the question, Mr. Murphy, please do so if you have knowledge.
I can only answer to the portion I have knowledge on, and I believe it was cited that the testimony of the media exposure was also a contributing factor, but I'm not an attorney.
Yeah, I think you're right about that. My question is, there were other factors in play. You may know that or you may not. Are you aware of that?
It's outside of my purview and role in this case.
That's not my question. My question is, do you know that that was in the order or not?
I will say no.
Okay. And we have had related cases related to this case tried here in Tallahassee. Are you aware of that?
I would assume you've tried cases in Tallahassee.
But co-defendants related to this case that we're here about have been tried here in Tallahassee. Are you aware of that?
I am.
Okay, thank you. In the spreadsheet, this was one, I think it was in Exhibit 1, Tab 1, where Donna Adelson and Charlie Adelson appearances in the media are lumped together. Are you familiar with what I'm referencing?
Is it the spreadsheet?
Yes.
Yeah.
Why were Donna Adelson and Charlie Adelson lumped together for purposes of that presentation?
I would have to speak with the client and the media monitoring team to see why that query was built that way. That would be my answer.
Were the numbers ever run for Donna Adelson alone?
I'm sure they were,
Stutter.
in the course of testing queries, we run many different ways. Ultimately, we arrive at a query that best captures the media exposure specific to what the parameters are around the case our client has asked us to be engaged on.
Okay, so I think that kind of gets to my next question. Who made the decision to lump Charlie in with Donna in the data included on Defense Exhibit 1?
I would say, I don't know. It would be a collaborative discussion between the client and our analysis team and our search strategist.
Okay, but ultimately, if you have data for Donna alone and data for Charlie and Donna together, who's going to decide what shows up in Defense Exhibit 1? You or the client?
It's going to be a combination. We would probably offer a recommendation, since in these cases, either name is probably not in the news for another issue. And we often would search to see if, I'll say, John Smith, if he's involved with the case as a alleged conspirator or whatever, also has a car dealership that frequently advertises that mentions his name. We'll check to see if there's other contributing stories. If there's not, then we'll make a determination that if it would be statistically impossible to mention Donna Adelson without mentioning Charlie Adelson, we'll run the names together because the query is functionally one subject. Now, if either party in that query starts to exhibit a volume of content on their own and not in relation to the other party, we would separate that and at least counsel our client that we should run this separately.
Okay, so are you able to tell the court how many of those articles that represent Donna and Charlie together, in how many of those does Charlie's name only appear in without Donna? So I'm not really after, I asked the question incorrectly. Let me start over. I asked how many for Donna alone, but what I'm really interested in is how many does Donna's name appear in, period.
That would be done with you could do a simple search in the spreadsheet and search not for the name Charlie or only for Donna and see how many of those 2,000 plus stories only mention one name.
Is that something you could do for us right now, or that's something that takes time and analysis to perform?
It would take, I wouldn't want to do it live on TV. I'd want to make sure we followed our methodology and protocol and have two sets of eyes check it.
All right, so you don't have that data to provide to us right now as far as how many does Donna's name appear in?
The data's there, we would just have to, or someone on your side or another could sort it.
Okay. When you're talking about opportunities to see a particular article or content, does that presume that all Leon residents actually have the same likelihood of seeing the content?
They all have an equal probability of being able to see the content.
Okay, but actual views could be consumed repeatedly by one viewer and not at all by another, correct?
That's a possibility.
All right, so if you're saying I had 376 opportunities to see this content, it's possible that I, as an individual, could have actually not seen any of it.
That is a possibility.
And it's 376 total opportunities over how many years?
I believe about 11.
Okay. And so I think in your math of memory, we can agree that the passage of time in general does not serve our memory well. Can we agree with that?
That is true.
Okay. So I would need to ask a particular juror, how long ago did you see the content and how much do you remember from the content to really know what that juror remembers, right?
To know what an individual knows or can reveal, that would be correct.
How many opportunities does the average person, adult, have in an average day to have an impression from any content? And I guess I'm thinking of, you know, waking up, picking up my phone, scrolling this morning, turning on the news, riding to work, listening to a streaming service on the way to work. You know, I've already been bombarded with a bunch of opportunities, haven't I? Just today.
I would need to know where you live.
Okay, but in general, let's just take the folks in this room that are sitting in here now. Like, we've already had a lot of opportunities to observe content. Would you agree?
I would think so. I don't know you, so I don't know what your propensity to consume news is.
But you deal in averages, and you're telling us what the average adult has the opportunity to consume based on that data.
Right. So I think if you look at the control story for a car crash, that would give you your answer. I think it was 6 opportunities to be seen or 4, something like that.
Right, but we're bombarded with this stuff all day, every day, is my point.
I don't see relevance to the question for me.
Okay. All right, so can we agree that actual memories of an individual vary? I mean, again, going back to what you were saying about I'm dealing with averages and probabilities, an individual might have differences based on their actual exposure to the content, based on their actual ability to retain information, based on their interest in the topic, based on what else is going on in their lives, their age, and lots of other factors. Would you agree with that?
I would.
It's hard to disagree with that.
You said the average person, the average Leon juror has been exposed, or at least had the opportunity to view material about this case 26 times. Is that right? Did I get that
That
right?
is correct.
Okay.
By the way,
And do we know
Ruth
how
is
many
watching
of
this. If you want to leave
those
her a message in the
26
chat, that would be nice. if you
contain
care
the
to do
name
so.
Donna Adelson?
She has to listen to this, which is unreal.
All 26 stories would contain the search term. So these are 26 opportunities to see the specific story about, I believe in this case, Donna Adelson.
Okay, but it's got Charlie lumped in with it, doesn't it?
Right.
Okay.
Yes.
And based on those 26 opportunities, you talked about the math of memory and how after a certain number of exposures, a person is likely to retain some of that information up to the rest of their life. Are you able to tell us what information is likely to be retained by a juror who's had these 26 exposures?
Yeah, it's the test on the model is can recall 80% of the details.
And so would it surprise you to learn that previously when we've asked jurors about this case, we get about a third that don't know anything, a third that know the headlines, and a third that have more detailed information? Does that comport with your work, or does that seem inconsistent with your work?
I'm unfamiliar with your procedure for selecting a jury.
Okay, but based on your analysis, does that sound about right? that that's what we would expect, or would you expect something different?
I can't, it's outside of my area of expertise. Jury selection, I don't do.
Wasn't the
But you're
question.
saying they would retain 80% of the information if they had been exposed 26 times. Is that what you're saying?
Yeah, I'm saying the probability of an average person in your county, I believe you're in Leon County, that would be the probability of an average person of jury selection age.
The probability of the average person of jury selection age who was in fact exposed 26 times, retaining 80% of the information.
Have the opportunity to be exposed 26 times.
Okay. But they definitely have to actually be exposed to get any of the retention that we're talking about.
That is true.
Then we can't know that unless we ask them.
Knowing, yeah, I guess I can. My work is in the probability of people before they enter your room. So all I can speak to is the probability of the people you might encounter during a jury selection process. I can't answer a question about who you will encounter during a jury selection process.
Right. Understood. No further questions.
I have a follow-up question, and from there, the parties can follow up as they need to. Mr. Murphy, I remember when you were testifying on direct that you were stating your numbers as it relates to the probabilities rely on the taking of the last census, correct?
Yes.
In any way, do these numbers account for seasonal fluctuations or
There you go.
shifts?
In terms of immigrant labor, or
Well, let me be more specific. Here in Leon County, we have 3 colleges and universities, meaning when you have a freshman class coming in each year, there are now 18-year-olds who will meet, presumably, juror eligibility. In that way, for that fluctuation of persons who may be eligible jurors by statute, does your data take that into account in any way?
I can't answer that without asking a question related to your fluctuating population. If you would like me to ask that question, I can, Your Honor.
You can ask. I'm not sure if I can give you much more, but go ahead.
So in the case of students, I have 2 children who've gone through college. Do they need to be registered voters? I don't know what the statute says.
They would have to have a driver's license that has a residency for this county. That would be at least the initial pull for coming into the juror pool.
So we would have to look at, let's say you have 20,000 students that fluctuate at the university level. How many of those have a Florida license?
20,000?
A valid Florida license, and how many do not? You can probably get that statistic directly from the university of how many out-state students attend each year.
Well, and would this impact what your numbers and analysis are?
He has to say.
Probably at a very, yes, probably at a very marginal level. Once you removed the out-of-state students and those who don't drive, then you're going to be left. If we started with 20,000 and removed those who aren't registered with a valid driver's license, the number would get down to a small enough number where it may impact the population of jury eligible students by maybe 10,000. A small number that statistically wouldn't shift this.
You're talking 60,000 college kids.
More.
3 colleges,
I
60,000.
believe also you stated as well, you made a comparison of your data to Nielsen ratings.
Yes.
how closely would you say that mirrors? And the reason I ask this is because a Nielsen rating or maybe a radio rating, I think the science behind it, they've tried to make it as detailed as possible because they're trying to use that information to monetize it, correct?
Correct.
But ultimately, even with a rating of that nature, when, say, it's reported there were 200 million people that watched the Super Bowl, that doesn't tell us, did you watch every snap? Did you turn it off at halftime? Did you turn it on in the fourth quarter because it was a good game? It can't really drill down. It's just ultimately, this is the big number that watched the game.
Right, on the gross number, that's correct. But when you're starting to get into
The relevant information.
Right.
the engagement level of the activity or the action within the media. So statistically, you can measure that people are more probable to watch a tight Super Bowl game that goes into overtime. The eyeballs on that overtime are going to be higher than maybe the middle of the third quarter. So you can show some statistics around topics or activity within the content. And that's what you would see in the numbers presented as evidence of a car crash versus, say, a murder. Murders are always going to gain a higher probability of attention, are going to have a higher probability of attention than the topics we're desensitized to, like a fire, a car crash, a fender bender, a robbery, things that we see and hear every day and don't engage with because psychological behavior, we desensitize ourselves to those topics.
Very well. Any follow-ups by the state to the court's questions?
No, Your Honor.
Mr. Zellman, you may redirect us to all topics, including the court's questions.
Thank you, Your Honor. I'm going to share my screen again, Mr. Murphy. On cross-examination, the state asked you about the 26 opportunities to be seen. To be clear, Exhibit 3, during what time period did those 26 opportunities to be seen take place?
If I refer to the charts,
Let me actually share my screen.
thank
Shout
you.
out to Phil Markel, who's in the chat. Great guy. Sorry you're going through this, Phil.
So this is the slide that you're showing now is the 1 year sample for comparison.
And so with the full set of data, that is identified in Exhibit 2.
Excuse me.
You can zoom in for the witness, Mr. Zellman, so you can see it clearly.
Thank you, Your Honor.
Well, not giving you the vision test again. Go ahead.
Now, the time period that is indicated in Exhibit 2 with 376 opportunities to be seen per person, what is that time period?
So that's July 2014 to January 2025. That would constitute what we know as the first story. The first story we sometimes even call the alpha clip, the alpha story, or the breaking news story. It should constitute that through the cutoff date in January of 2025. In order to do an analysis, we have to have a specific starting and a specific end.
So during that roughly 10 and a half year period, there were 376 opportunities to be seen
In Leon County.
in Leon County. And then
Per person.
and since then, since January, that number has remained constant or has it increased?
If there's been any media coverage, which we know there has been, then that number has gone up. since we are presenting that in the analysis, I will speak to how much. But I stated earlier, we are on track to exceed 2024 total opportunities to be seen based on media coverage and impressions. And when I say we, I'm referring to the media monitoring side of TrueScope.
Boy, he fell apart on cross-examination.
Boy, did he ever. God.
He agreed that jury selection would be the best way to fix it.
Well, it's obvious, isn't it?
This is where
He's-
you're indicating that 2025 is on track to exceed 2024.
Correct.
And 2024
I mean,
had over
Zellman is
92
just doing
million
this for
media impressions.
Donna.
Yeah.
Right. And that would speak to the fact that each individual of jury eligible age, I'm sorry, that would speak to each person in that designated market area, in this case, the entire state of Florida, has the capability and as the prosecution pointed out, a person can consume more than one story. And as the model for memory shows, each time you see another mention, you have the potential to strengthen your knowledge on the details of the story.
Donna looks very subdued, either naturally or with the help of
Slide
something.
2 of exhibit 3,
Medication.
Yeah.
you indicated in your direct testimony.
Shout out to
that
Katie Cool Lady, by the way.
This represented, there were some peaks and valleys when the volume of coverage was greater or lesser. So if I were to tell you that the initial arrest took place in 2016, would that correlate with the data where there was a significant increase in the number of stores?
Yeah, we would look through that number to make sure that you're correct, but that fact that you state is or would be indicated by that peak.
Shout out to
Saying
Julie
that
Frew.
in 2019 was the initial trial. Would that also correlate with the peak in the data that's identified in exhibit slide?
Yes,
Exhibit.
anytime there's an element to a long-running topic in the media of significance, you'll see a peak like that.
And so is it fair to say that the length of time or when key events happen, such as trials, the media coverage increases?
Yes. And that's a simple function of the media. They want eyeballs and they know what stories have interest to the community they serve or may not have an interest to the community they serve.
Just a moment, Your Honor.
Go ahead.
God bless you too. Ooh,
You know,
good
it's
camera
obvious.
movement.
They don't do, I don't know how many, their focus is not trials, clearly. And when they went ahead and used the data they use in other situations rather than the data that would have been more relevant here, which is the jurors that would be eligible to serve on the jury, people who would be eligible to serve on the jury. So they start out in the wrong place because, they just use their standard way of doing things without tailoring it to the questions in this case, which is really, statistics can be manipulated. I saw Phil say that.
Yeah.
But, part of the problem is if you're not doing the right data collection at the front end, you're not going to get good information on the back end or any. And then I don't like it when you mix, and that's what they did. They talked about 80% if you've actually not engaged, but you've actually seen. And then the number that they give you is just the number of newspapers that published the article or broadcast stations that broadcast it. I mean, Tim wrote an article for the paper yesterday and he was affirmatively looking for it and didn't see it. So what does that do for everybody else? I mean, you can't just prove that because it's in the paper, because it was on TV or on the radio, anybody had any encounter with it. But they're using
One
that
last
number to
question,
say
Mr. Murphy.
80% when the 80%
Based on
doesn't
the
relate to
analysis
that
of the
number.
data
Yeah.
That was collected in this case, is it fair to say that the overwhelming number of publications and broadcasts took place or were presented in Leon County?
Could you say that one more time, please?
Sure, sorry.
You can't say podcast for
Based
it.
on the analysis of the data that was conducted in this case, would you agree that the overwhelming number of publications and broadcasts concerning the story took place in Leon County, Florida?
That is correct. Yes.
And that, statistically speaking, Miami-Dade County, with a significantly greater population, has a significantly less
This guy's trying
media
to sell
exposure
ice
in
in
this case.
Arctic.
That is
He's
true.
not getting this case to Miami.
Nothing further.
You know what they
Therefore,
say,
that
there's
concludes
lies,
your
damn
testimony during
lies.
this hearing. You may remain on the
That's what you
Zoom
can
if
say
you
about
desire to do
statistics
so.
too.
And
Yeah.
now going to speak with the attorneys as to their arguments on the law or any other evidence if they have to present it.
This is just horrible.
Thank you, Your Honor. Is it standard operating procedure that it would remain, or do people normally exit?
You can exit or you can stay. It is up to you, but you are free to go.
They want-
Okay. If I needed further, please let me know.
I'll call you.
Thank you, Your Honor.
Mr. Zellman, any other witnesses or evidence that you wish to present?
Your Honor, can we have a 5-minute recess, please?
That's fine. I will stop the clock during the recess.
Well, thank you.
5-minute break. We'll go to about 10:50.
Thank
So
you
you
very much,
need
Your
an
Honor.
expert to tell you
6
that when a
minutes.
trial is on, there's likely to be more media coverage than when nothing is going on and it's a year away.
Yeah. I mean, these
Gee,
expert witnesses, I mean, this is like a whole cottage industry.
I know.
I mean, I could get hired to be a media expert, and I don't know what the hell I'm talking about. And I don't know what this guy knows. I mean, it's laughable. But Tim, if you want to hire me, my fee is $45,000 a day.
He found another avenue to get money. They found him that he participated in the Idaho, so they jumped on board. He didn't know what he was talking about, and then he couldn't compare it to actually jurors.
Right.
He didn't understand there's 3 colleges here, which is
Right.
about 70,000 students.
Right.
And he never answered the simple question: how much has your firm been paid as of this date?
Yeah. Now, doesn't he
never-
have to come in with that? He wasn't prepped at all, or
No,
not
he
very
said
much,
he
or
said
not
his
very well.
he'd have to speak to his accounting department.
They got to know that, and that's ample for cross-examination.
Mhm.
By the way, I have a feeling so this guy said his father started the business and he took it over, but now it's based in Australia. So I'm thinking he sold this thing for boatloads of money and maybe just stays on because he's not listed as a founder or CEO or anything, or at least
He
currently.
said he was the president, didn't he? What did he say at the start?
I think that's what he said. I thought he said he was the founder. Oh yeah, president. That's what I have
President.
written down.
Yeah.
Yeah. By the way, for those who don't know, this guy's name was Todd Murphy. He is the president of a company called True Scope, which does media intelligence and analysis.
Yeah.
I'm offering up my own services to anyone who needs it. And again, I charge $45,000.
Yeah, but your
a day.
problem is you already said where somebody could hear it that you don't know anything about it.
Yeah.
You should
Yeah,
not
that's
have said that if you wanted to get hired.
They said media monitoring, media analysis, tracking and indexing. And then
Right.
for broadcast data, they have an aggregator. They also look at podcasts and social media, yada, yada, yada.
But their
I'm-
typical clients are PR and marketing firms, nonprofits like universities,
Mhm.
not trials,
No,
not
100. Yeah.
this.
People use this like Johnson and Johnson. I'm just making this up out of my, the CEO of that company wants to know every time he's mentioned in the media for what, they just want to keep track of it. And that's who hires these people. It's corporate people. It's not really media people per se. It's for businesses so they can keep track
Right.
of how much their executives and or their companies are being mentioned. And that's what they do. And by the way, this entire business is going to be eradicated by AI because you're just going to have an AI bot that can spit this all out eventually. But I mean, Tim,
Yeah.
I guess he's pushing for Miami, Zellman. I mean, he'll
That
be
just
better off to go to Vietnam, right?
it kind of reminds me. It kind of reminds me of my client in South Florida in federal court. He scored like 8 years. The state wanted 10, and my client wanted house arrest. And I told my client, you can't ask for house arrest. You lose all credibility. And even the judge goes, so the state wants this, you want this. Well, this is what we're going to do. He didn't get house arrest. There's no chance this is going to South Florida. I would assume that Don is asking for that. I was conversing with Charlie's lawyer during this, and they were hoping he gets Jacksonville or Gainesville. So I don't know. I do not think it's going to be granted. I don't think there's a basis for it. I think it's premature. I think the case law that they cited is not comparable. And I think this guy's statistic is not relevant. I think the law says you have to try to pick. And I think that's what the judge is going to rule.
Yeah, I agree completely. I don't think this moved the needle at all. It just highlighted that the way you find out is to ask the jurors, the
And that's what
potential
he said.
jurors.
That's what he said.
And he said it. I know.
Yeah.
It's called voir dire. Shout out to Markless Sky coming to us from Melbourne, Australia. It's a horrible accent. Shout out to the COE for keeping us all together. Space Coast on the West Coast, handling the tech, the great mods, and shout out to Steve Cohen, who is mourning the loss of his mother, but seems to be doing well. I've been talking to him via text. So, and he's, by the way, very grateful. I think the COE set something up on our community tab. If you want to leave a note for Steve, and he was very appreciative, and he's showing that to his family. So,
nice.
Thank you. Murray Muncie, I'll get up on that stand, but again, it's going to cost Donna $45K. I don't know. I just made that number up. Is this Joe Potuto? Is this just all an exercise in futility? Is this just STS Nation getting together for I don't know, for no?
I would yes, because not only I think Tim is absolutely right. This motion is certainly not going to be granted now. I don't think it's going to be granted at all, but certainly not now. But there's nothing in what they presented here that would help on an appeal.
Yeah. By the way, I've got to break in here. Sandra Hannon watching from Rwanda. A little known fact, the COE and I, on our honeymoon of all places, we went to Rwanda and we went to Tanzania. And Rwanda is an unbelievably beautiful country that experienced its own genocide. But I can't believe we have someone watching us in Rwanda. And that is the time that the cab driver, the COE didn't wear her actual engagement ring, but wore another ring. And the cab driver did not understand why she would have a ring like that. And he explained that in Rwanda, when you get engaged, you give your fiance, you give them a goat so you can get milk from the goat. Yeah. And I am going to start a grassroots campaign in America that every fiance should be given a goat instead of a dumb diamond ring that is pointless. But that's my own.
I don't think that campaign's going to go very far.
I don't think so either. By the way, my best friend is in the diamond business. KJ and the Ray, payment to this channel for the common sense. Oh, thank you. Appreciate that, KJ. Yes. Yeah, I still can't get over it. We've got Jamaica in the house and Rwanda in the house. That's wild to me. So, Markless Guy, thank you. Melbourne, Australia. Next time the UFC is down under, I'll have the COE treat me to go into the fight. Bill Davis wants the trial moved to Virginia Beach so he can go to the trial. What are some other interesting places for? I mean, the trial would be interesting if it was held in Rwanda. Never shouts out Canada. I shout out Canada all the time. Toronto, Montreal, Vancouver, Ottawa. I shouted out 2 nights ago. Go ahead, Joe.
I think it should go to Vietnam. That's where Donna wanted to go in the first place.
She'd like that.
Yeah. Ironically, my cousin right now is working in Vietnam. She does international aid work and she's in Vietnam. So I could go visit my cousin and I could go watch Donna Adelson. Who has been to Vietnam in the chat? Let us know.
Hey, Joel, in Greece,
Yeah.
they say that the bride's family gives the couple a house. And they said the bigger the house, the uglier the daughter. The smaller the house, the prettier the daughter.
Now we're going into the politically incorrect area.
Tim Jansen,
I
Tim Jansen, I would be living in a shoebox. Tim Jansen.
want to give you a pet peeve. I have a list of Potuto's pet peeves that I create.
Oh, please.
And somebody like Josh Zellman, who says it goes without saying and then says it, is one of my pet peeves.
Yeah. That's like Carm saying no offense, and then the insults are coming right after one. But my biggest one is me personally, because that is just redundant. Just either me or personally, or how about just personally? But
how about when they say truthfully? Truthfully. Well, I hope
so everything else you said was a lie, right? It's a negative pregnant, as we say in law.
Yeah.
A negative pregnant. Yeah. I'd like a goat. Do you think 51 years is too late? No, I think you should please ask your husband. Kenya's in the house. This is unreal. Welcome, Kenya. Erica Whiteside. Norway's in the house. Let us know the exotic locales, including, Newark, New Jersey, and other exciting places. Katie and Sigfredo scheduled to testify. Tim, I imagine Katie, but Sigfredo is probably not going to open his mouth, right?
I will talk to my close source on that one, Monica, since she worked on that, but I haven't heard.
LP Clement says she wants a cashmere goat. Let's see if we can arrange for that. By the way, little known fact, we went to Rwanda and we met these young children, and then the COE had an ingenious idea of starting a nonprofit for kids in Rwanda, and then she went back with her friend from college, like maybe a month later, to Rwanda by herself with her friend, and I'll just leave it at that. Look, the Philippines is in the house. Love that. Sigfredo Garcia has been moved. We are keeping an eye on Judge Stephen Everett. So I never shout out Vancouver. That might be true. You're kind of far away from me. That's why you're not like in my line of sight. But shout out to Vancouver. And right now, by the way, in Washington State, they're looking for this guy Travis Decker, who's accused of asphyxiating his 3 daughters. They believe he's alive. Terrible. And they're trying to hunt him down. But I'm shocked that guy is alive and is not taking his own life. Greetings from New Mexico. We've done a couple. Here's Judge Everett coming back in.
Friends have any other witnesses or testimony as a part of this presentation?
No, Your Honor.
That's it.
Very well. State, you may make your rebuttal presentation if you have one.
Judge, all I have is a thumb drive that I prepared as State's Exhibit 1. I intended for it to contain the 3 prior jury selection transcripts on the related cases, but for some reason we weren't able to find the first one, so it contains the most recent 2 transcripts of jury selections conducted in the related cases, co-defendant cases. I'd like to admit that for your consideration.
Is there any objection from the defense?
I don't think there's a legal objection to that, Your Honor.
States 1 as the thumb drive is admitted as well. Any other evidence or presentation?
Just argument, Judge.
Yeah,
Can
it's
you make
weird.
your argument, Mr. Zellman?
Thank you, Your Honor. Your Honor,
no,
as
She's
you're
there. She's there.
familiar with my practice, I tend to put it all on paper. And I did that in this case. I do want to highlight a number of items, though, Your Honor. In Exhibit
Thank you, Mark.
And Exhibit 5 is listing of the podcasts. 77 pages long of individual podcasts. There is some overlap between platforms. However, it's not just the podcasts that
Thank you, CBO.
we're asking the court to consider, but also what people are saying during those podcasts. The effect on the listener that those podcasts have and the comments that the public makes.
Watch yourself,
where
Zellman.
We are seeing the
Here we
most
go.
significant prejudice, the vitriol towards Mrs. Adelson, to her son, to her daughter. And we also see in those a number of podcasts. I ran a search yesterday. I counted over 20 different episodes just focused on inadmissible information. As Your Honor is aware, prior counsel in the state, you had an in-camera hearing last September. I'm not going to go into detail about what was contained in that. Unfortunately, back in December, when Your Honor authorized that to be transcribed, it was not sealed when it was posted to the clerk's website. Media outlets from all over the country obtained that information. They obtained the transcripts. They published the transcripts in full. They analyzed them in their podcasts. So now what Your Honor has ruled to be inadmissible is out there. It's out there for and as I said in my motion,
Yeah,
can't
it's out
unring
there
that
everywhere.
It's
one
out
of the
at
factors,
every
is-
venue.
Yeah.
whether the publicity has included information that would be inadmissible at trial. In addition to that inadmissible information, we still don't yet know which audio recordings the state intends to seek to admit in the trial. However, there are audio recordings that we submit would not be admissible against Mrs. Adelson. It's our position, Your Honor, that co-conspirator exception, the conspiracy ended when the murder took place.
That's not true.
Conspiracy did not continue to extend beyond that.
That's not the law.
As a result, any of the statements that were made in 2016 on the wanted by other individuals, other than Mrs. Adelson, are not included under the co-conspirator exception. And those would be.
We would have to, I think, handle this through a separate motion in limine or argument as to that hearing. But as to the completion of the murder being one part of it, yes. As the conspiracy being ongoing for
Right,
the
Cover up the
conspirators
crime.
never
right.
Covering up the
right,
to
murder.
reveal what their role is.
Right.
Does that ever end, Mr. Zellman?
I'm sorry, what was the last part?
It
For
does.
the persons who may have participated in the conspiracy, would that not always be an ongoing thing? So their role is never revealed.
The way that this is charged, Your Honor, I would say no. It's charged with conspiracy to commit a murder, not conspiracy to cover up a murder.
Very well, please continue.
So you have, it is our position, inadmissible information that has been publicized. And it's nobody's fault for the vast majority of that information. This case has been tried 3 times. Each trial has been live streamed. All of the testimony has been publicized. So as to what could have been done prior to our involvement on behalf of Mrs. Adelson, all of that evidence was already out there. And it's our position, Your Honor, that with respect to those statements that are not admissible as to Mrs. Adelson. And to back up, Your Honor, once the state identifies which wire recordings they intend to use, we certainly will file a motion in limine and ask for a pretrial ruling, so we're not dealing with that during trial and potentially wasting the jury's time. But we can't do that just yet, because we have to wait for them to identify the calls.
And you're referring to the most recent wiretap or the wiretap from 2016?
Both.
Very well.
Another factor that Manning tells us to consider is the timing. I'm sorry, Preston Oates tell us the timing of publicity relative to the incident and the trial. So historically, courts have said, okay, well, we're going to continue this trial a year, 18 months, 2 years, so that the original publicity has died down and that won't factor into potential jurors' minds. That's not something that exists in this case. As exhibit, let's see, I believe it's exhibit 3.
Jared makes a good point here.
Indicates the publicity that has taken place in this case has not died down. There's been an ebb and flow over the years. So initially in 2014, there was, obviously that's when it first happened. There was significant coverage that died in 2015 during the investigation. And then in 2016, once the arrests were started, the initial plea by Mr. Rivera was entered, and Ms. McBanner was arrested. There was a great deal of volume of coverage. 2017 and 2018, it died down. 2019, the first trial, it increased significantly. And then in 2020, 2021, it died down. 2022, during Ms. McBanner's second trial. 23 for Mr. Adelson, Charlie Adelson's trial. 2024, 2025, all of those increased. And as Mr. Murphy indicated in his testimony and in Exhibit 3, specifically slide number 3 of that exhibit, the media coverage in 2025 is on track to suppress last year's totals. Last year's media impressions exceeded 92 million.
Yeah.
So
wait, 92 million
tells
what?
us that the timing of publicity, it's not going to die down. It's going to continue to circle. I mean, we're sitting here, we have reporters typing behind us. This hearing is probably being
It's a public trial.
That
broadcast
sounds
live.
like Kim Jong-un.
And so that weighs in favor of granting the motion.
No, it
So there'll be
doesn't.
no reporters somewhere else?
Chop his hands off the guy that's typing.
So
Still
he
the worst
argued
argument
about
I've
the inadmissible evidence, but then he files a motion for change of venue.
I
The
know.
defense
Right.
filings or
As an
filings by the
exhibit,
state in particular play a
prejudicial
role in
material.
those.
I'm sorry?
Didn't file
The
on
defense
video.
filings or filings by the state with the pleadings play any role in those?
Here we go.
Yeah, he didn't do them under
I
seal.
don't know that I
No.
can answer that. It's one of the reasons I think that we had filed the materials in support of this motion under seal, so that the information was not highlighted again for the media.
He originally
We-
attached the article about Robert.
Obviously,
Yeah.
court records are public with limited exceptions. So I don't know how that factors into it.
Very well. You may continue.
I think I don't know is when you don't want to say yes.
I'm going
Right.
to start saying
With
very
respect
well.
to all of the podcasts that have been identified in Defense Exhibit 5, as well as any commentary
Tim, is this sealed or can we get this?
that is contained within
I
those
think he said
podcasts,
sealed.
I think that part
members
is
of the
seal.
public
I think he'll
are
cite my
able to
article in today's
provide their own
Democrat.
insight on. Your Honor, reviewing
I don't
that
think he's
information,
current.
becomes clear that the community's hostility towards the defendant is overwhelming.
Mm.
The sentiment from all of those podcasts, not necessarily the hosts of those podcasts,
Oh,
Oh,
Joe.
you're
for a vast
exempt,
majority
Joe.
of them, yes, for the host, but for the people who comment,
Mm.
It's you and me,
in
Tim. We're
on
on
this
the,
podcast,
on
the
the
vast
docket.
majority of it
Yeah.
exhibits
We're on the
hostility
dock.
towards the defendant.
He's calling out
Truth-
STS.
truth
Intro.
hurts.
Almost every single one of them where you have the talking heads offering their opinions.
Talking.
The vast majority of them offer their opinions about Mrs. Adelson's guilt or innocence and are publicizing it. and the vast majority are saying that she is guilty, and they are skewing the reporting in a way to support their theories. All of that's in evidence, Your Honor. I'm asking the court to consider that in reviewing the factors that the court is supposed to consider. And I want to highlight, Your Honor, before I wrap that up, actually, there is another factor that needs to be taken into consideration. And that's when a confession is featured in news media coverage
What
of a
confession?
prosecution.
Did I miss
Confession
something? She confessed?
of
I
Mr.
don't know.
Rivera and Catherine McBanawa. It's not only been published, but their testimony has been broadcast on live television, summarized in local print news media, as well as the podcasts. Now, I recognize
Let's break them down as individuals, because with Mr. Rivera, I believe his testimony has always been that he went and did a murder for hire as a paid job. He did not know who
Hired him.
essentially the principal was, but it was organized through his friend's girlfriend.
correct.
In that way, how exactly is that a confession that implicates your client?
It's not. Unless she's a
I'm trying to
co-conspirator.
find that part here. Let's see.
He needs to look down to his notes to answer that?
He's not good public speaker. He
Yes,
likes
Your
to
Honor,
talk.
Mr. Rivera is not as significant a factor as the testimony of Ms. McBanawa.
Okay.
Her testimony in Mr. Adelson's trial, her proffers, transcripts of which have all been released to the public, and the recordings of which I presume have all been released to the public, detail her recitation of what happened and directly tie into Mrs. Adelson's alleged involvement in this this murder. So now I recognize that factor comes from Oliver. As I indicated in my memorandum, recognize that Oliver has been restricted and refined. In Hoy, one of the cases that restriction refines Oliver, the detective summary of the confession was published, as well as 3 contradictory statements made by the defendant. Here, no statement by Mrs. Adelson has been published except for the statement that was released, I believe, back in 2016 by her then attorneys, denying any involvement. However,
That was a statement she made, or just that the attorneys made in response to a press release?
it was a press release from her attorneys.
Directly quoting her, or just
No.
on behalf of the family in
It
general?
is on behalf of the family. That's the only thing I believe that has been published on behalf of Mrs. Adelson. But it's not a statement directly from her.
Please continue.
So you have the confession as another factor there. And what I want to say, Your Honor, is quoting from Singer versus State, the Florida Supreme Court said, every trial court in considering a motion for change of venue must liberally resolve in favor of the defendant any doubt as the ability of the state to furnish a defendant a trial by a fair and impartial jury. Every reasonable precaution should be taken to preserve to a defendant trial by such a jury. And to this end, if there is a reasonable basis shown for a change of venue, a motion therefore properly made should be granted. A change of venue may sometimes inconvenience the state, yet we can see no way in which it can cause any real damage to it. On the other hand, granting a change of venue in a questionable case is certain to eliminate a possible error and to eliminate a costly retrial if it is determined that the venue should have been changed. Your Honor, it's our position that although a jury has been seated previously, media coverage, and again, when I'm saying media coverage, I'm referring not just to print and broadcast, but also to the podcasts that are in evidence, overwhelmingly points to the fact that seating a fair and impartial jury in this venue is going to be impossible. And in order to avoid the expense associated with making that attempt, the court should now grant the motion for change of venue.
As
Denied.
to both Singer and the cases that follow it, does this argument account for the most recent Florida Supreme Court precedent on this topic? The cases that go to not only must there be prejudicial media coverage, but there was an attempt to seat a jury and you could not seat one.
There you go.
Your Honor, it's our position that the case law is still valid. I'm not sure exactly which case Your Honor is referring to.
He
I'd
doesn't
be
know
happy
the
to look at
recent
it.
Florida
Smith
Supreme
Smith
Court
versus
case on
State,
this subject.
320 Southern 3rd,
Wow.
20. Case from 2021,
I'm sorry, Your Honor, you said it was 320 Southern.
3rd,
Wow.
20. Donald Smith versus State of Florida, and deals with, this is a death penalty appeal, but deals with change of venue along with other issues. Cites to Griffin versus State and Rawling versus State, and deals with the issue of pretrial publicity.
Can I have a moment to review that, Your Honor?
Go ahead.
Tim, what about this possibility of him not allowing cameras in the courtroom? What do you think the chance of this is Florida? Probably
No chance. There will be
Good.
cameras, not federal court.
Good.
We lean towards public trials.
Mhm.
You have a
Yeah.
public victim, you have public crimes. People are
Yeah.
entitled to know what's happening in their courtrooms.
Joe Potuto, he seems to have a particular animus towards podcasts, even the way he says it. I'm serious. Like, he's not coming down on Dateline or 2020, but I guess, podcasts are quite opinionated and they're not as structured as corporate media. Is that the problem, you think?
Yeah, no, yeah, I think that's what he's talking about. And it's true. Yeah, I mean, you can't quarrel that the newspapers and the broadcast reports are shorter and they're going to be more straight on, here's what happened, because they're not doing opinion. If somebody did an opinion article for the paper, you'd get something equivalent to what happens on a podcast. I think they should have left off their expert and just had him do this, because I wasn't overly persuaded here, because they've got to try to sit the jury before they get to the conclusion that you have to lean towards the defendant, even if it inconveniences the state. But I thought this was much more effective than their witness was.
I agree. And especially when you turn your witness into a witness for the state that agreed that picking the jury was the best way to
I know.
determine
Yeah.
whether or not you can get a fair jury.
And I don't know how he could make this argument and not know a 22 case from the Florida Supreme Court on this subject.
Tim, I was going to ask you earlier before Zellman gets going again.
Your Honor, just briefly reviewing Smith and Griffin, both involved in analysis of fundamental error. In both cases, trial counsel did not obtain definitive rulings. One of them, I believe in Griffin, Your Honor, trial counsel didn't file a written motion, brought it up just before jury selection and didn't object when the veneer was sworn. Smith, same issue happened there. Smith attorneys did not renew their objection or request a final ruling on the motion for change of venue after the jury was selected. So those, I believe, are distinguishable from what we have here.
He's arguing
Ultimately,
procedural.
with that, we are not talking about an issue of review for fundamental error, as no review would even be ripe yet at this point.
Thank
But
you, Katie.
as
Cooley.
to the test that it lays out,
That's right.
in exercising discretion regarding a change of venue, a trial court must make a two-pronged analysis
There you go.
evaluating the extent and nature of any pretrial publicity and the difficulty encountered in actually selecting a jury.
Done.
As to that, is that the applicable test the court must use?
I would say that applies when jury selection has been attempted, but my research indicates that no Florida Supreme Court case has overruled the test set forth in Singer that pretrial publicity on its own can still be a basis.
He doesn't understand case
As
law.
a point of law, I don't believe your reading of Singer is wrong. However, these cases are refined over time. I believe Singer was 1959.
59.
Yes, sir.
Oh, boy.
Cases that are almost as old as my father. They're still good, but they do change over time.
I agree, Your Honor. But it's the
He just got slammed.
case law also cannot
Oh,
be
did he ever?
um,
Did he ever?
overruled by implication. No higher court, no Florida Supreme Court case has said definitively that Singer is no longer good law.
Very well. State, you may provide your rebuttal argument.
Are they still citing it even? I'll bet
No,
they're
no
not.
one cites it.
Yeah, I bet they're not. Yeah.
1959? Come on.
Yeah.
What I learned from the defense expert is that there's been a lot of publicity in this case, which I think we all already knew, as is their right to report on a case that's been of high interest to this community, and that we have a high probability that we'll encounter some prospective jurors who know something about this case. Something I think we all already knew. What and how much and whether they formed a fixed or definite opinion are factors relevant only to those individuals and can only be learned at jury selection. Similarly, who has consumed inadmissible or discussions of inadmissible evidence? We can only learn that by asking them who's listened to these particular podcasts. And I trust that the defense will do that. I also expect that it will be relatively few. Maybe I'll be proven wrong, but again, the fairness that we're guaranteeing her of this trial is through that jury selection process, that those jurors will be asked those questions and that if appropriate, they will be stricken. To secure a change of venue, the defendant has the burden to show this court that there is a reasonable likelihood that prejudice against her in our community will prevent her from receiving a fair trial. How do we know if the facts or the media coverage of a case has prejudiced us such that the citizens of this community where this crime occurred are not capable of rendering a verdict based solely on the evidence that's presented in court, except in the most exceptional circumstances, which I can imagine, to answer your question about Smith versus Singer, I can imagine, maybe a George Floyd or a circumstance where the answer might be to avoid attempting to pick a jury because there's no point there. But this certainly isn't a case like that. The defendant in their own motion cite Lozano. Lozano is a third DCA opinion, not binding on this court and distinguishable from our case. But according to Lozano, a change of venue is appropriate where legitimate community safety concerns might influence a jury's verdict. Lozano was a racially charged incident in which a Miami police officer shot and killed a motorcyclist and his passenger, whereby they then crashed into two other citizens, injuring them. And it sparked protests in that community immediately upon the incident occurring. There were riots in the Miami area, which caused school closures. 130 block area of the town was cordoned off for crowd control, and the use of tear gas was deployed against the members of that crowd by law enforcement. So in the Lozano opinion, the court said that a fair trial could not be conducted in an atmosphere in which the entire community was so obviously, penetrated by the feels that resulted from this incident, which was basically like a lightning rod in the community. And the court
You literally couldn't get through the courtroom door, essentially, to start the case.
Right.
That's right.
I can imagine a situation where you can't pick a jury under a situation like that, where the jurors are potentially concerned about their own safety or the safety of the community if they render a particular verdict over the other choice. Dan Markel's death was felt deeply by many in this community. I certainly would never argue the contrary, but it's distinguishable from an incident like Lozano, which involved a community reaction driven by underlying social, economic, political factors, widespread fears within the community, and is prone to sparking something like a violent outbreak. Nobody's going to start a riot based on Donna Adelson's verdict, whichever way it goes. Next, defendant cites Manning, a case in which there was a change of venue granted, but that cites McCaskill, where the test for venue was set forth, or the test for change of venue, I should say, but in which, in McCaskill, the motion for the change of venue was actually denied. And the court said a determination must be made as to whether the general state of mind of the inhabitants of the community is so infected by knowledge of the incident and the accompanying prejudice, bias, and preconceived opinions that the jurors could not possibly put these matters out of their mind and try the case solely on the evidence presented in the courtroom. What the defendant left off of that quotation in her motion was the sentence that preceded that quote that I just read, which states, knowledge of the incident because of its notoriety is not in and of itself grounds for a change of venue. All we've got right now is suspicion that several jurors are going to have knowledge of this incident. We have a case that's gotten a lot of media attention and has gained notoriety in our community. But to conclude that this case has rendered our entire citizenry incapable of giving Ms. Adelson a fair trial there's no evidence to support that. Manning was also a racially charged case involving the murder of two well-liked white deputies by a young Black defendant in a small rural community. There were about 31,000 people in Columbia County in 1976 when the Manning case occurred. A voir dire inquiry in that case revealed that every member of the jury of an jury had significant knowledge about the crimes. That is not what I anticipate we'll have here. It's distinguishable from this case where we have successfully selected 3 prior juries on related cases under similar circumstances with similar media attention. And I would reference states 1 for that, which is the transcripts from trials 2 and 3.
Well, to that point, and I don't think the state is really disputing the mathematic analysis that has been provided by the expert, there has been a spike as the various trials have gone on, correct?
Sure, there's more content out there. I think some of the content is the same that's being hit over and over. And I think the problem with the analysis from the expert's perspective is that we're just going to divide all the content by all the people and spread it out evenly among all the people. And that's just not how the world works. Some people are going to pursue content. Some people aren't going to see it at all. Others are going to just look at headlines. Those people are still eligible to be jurors unless they formed a fixed or definite opinion about guilt or innocence based on those headlines. So to, divide all content by every eligible juror and say, oh, you've all got 376 exposures to this, you're all ineligible, is just fuzzy math.
So you're saying going from the general of what the math might be to the specific of if we take random person off the street, we still need to ask, what do you know? What have you heard?
I think so.
Please continue.
If you're watching
That would
Leon
be
County, let us
appropriate in
know.
this circumstance.
Let us know.
I'm not saying it would be necessary or required in all circumstances, but certainly here, where the media content, yes, there's a spike because something's going on, stuff is happening, but it's the same, I think, going to turn out to be the same people consuming this stuff over and over and over again, and those people probably won't be eligible to be jurors, but as we've learned from experience, there's going to be a lot of people that are still eligible, and I think we should at least try before we take this case away from the county in which it occurred and move it elsewhere. Certainly, I can't imagine a planet on which we move this case to Miami, which seems to be suggested by the defense. I mentioned when I was cross-examining the expert who had no knowledge of this, but I think that State's Exhibit 1 will reflect that about a third in our individual voir dires on previous jury selections had no knowledge of this case, which might be surprising to some of the people in this room who are consuming it regularly, but it's not everybody consumes this stuff. And about a third had very limited knowledge. Those people are still mostly eligible to become jurors. And then there's a third that have more detailed knowledge, and some of them didn't have fixed opinions and were still eligible to become jurors in the case. So while many jurors were disqualified in those proceedings based on their knowledge and their feelings about the case, there were plenty that weren't. We picked a jury in 2 days on the first 2 trials and in 3 on the third. On the third trial, we had a defense jury expert flown in from Manhattan to drill down specifically on individual voir dire regarding publicity. And that was a time-consuming process, and we still were able to successfully get an unbiased jury that was agreeable to both sides in 3 business days.
I'll review your exhibit, but do you recall of the jury that was actually selected, what was the breakdown of no knowledge, some knowledge, or stated they would set their knowledge aside?
My recollection is that it was roughly a third, a third, a third. But
And this is the most recent jury.
yes,
Go ahead.
I've just noticed that pattern both in voir dire, who we end up with, repeating itself throughout, my life that has become this trial. It's happening over and over again. So can I say specifically that what we ended up with was that breakdown? No. But that has been my observation over time, is like, gosh, there's a third of the community out here that still has never even heard of this thing. So I'm suspecting they're still out there. There has been a peak. Maybe we'll try and learn otherwise, and it won't be possible. I don't think that's going to happen, though, Judge. We were going to weed out the folks that are not eligible until we get down to a panel that's acceptable, and then we're going to proceed with other questioning. Since we've selected, 3 jurors previously, I don't think this recent spike in activity of media is going to somehow make it impossible to get a jury this 4th time. I did want to cite Copeland v. State. I have a copy for Your Honor in the defense if you'd like, but it's at 457 Southern 2nd, 10-12-1012, a Florida Supreme Court case from 1984, in which the court held that a widespread public knowledge about the case is not the focus of the inquiry on a motion for a venue change based on pretrial publicity. Rather, the critical factor is the extent of the prejudice. So what is the prejudice? Defense has really only pointed to these podcasts with opinions about guilt and inadmissible evidence being discussed to really talk about this hostility and this prejudice that's out there. And I think we need to ferret that out through the jury selection process to determine whether that has really infected the jury venire as a whole. I think we're going to find that it has not, and none of the expert testimony related to that. The court goes on to say in Copeland that if it is possible to impanel a jury that can be relied on to decide the case based upon the evidence and not be influenced by knowledge gained from sources outside the courtroom, then a denial of a change of venue is proper. Again, in Copeland, every member of the jury panel had read or heard something about the case, but because all of them said they could set aside that information and render a verdict based solely on the evidence presented in court, the motion for a change of venue was properly denied. I also want to draw your attention to Hanyard v. State, Hanyard, at 689 Southern 2nd, 239. So Supreme Court case, Florida Supreme Court, 1996. This was a death penalty case in which the court said that absent extreme or unusual situations, like what we saw in Lozano maybe, the need to change venue should not be determined until an attempt is made to select a jury. And this goes to the Smith case that Your Honor brought up earlier. In Hanyard, again, all the prospective jurors had heard something about the case, but each agreed they had not formed a fixed opinion about guilt. Each agreed to consider only the evidence presented in trial in making a decision. And so the motion for a change of venue in that case was also properly denied. We have not yet attempted to select a jury, but we have every reason to think we should, as recommended by the Florida Supreme Court. Your Honor brought up Rawling v. State, and I highlighted that one as well, that outlines the 2 prongs. Prong number 1, the extent and nature of the publicity. We do have extensive publicity, but I don't think we have sufficient evidence that the nature of it has been improper or inflammatory such to infect the jury venire as a whole. And the second prong, of course, is the difficulty encountered when actually selecting a jury. Again, we should, but have not yet tried to select a jury. And again, we have the benefit from the previous efforts to suggest that we will be successful in selecting a jury in this case. In page 3 of defendant's motion, she relies on Oliver for the proposition that published confessions should equal a venue change. Oliver was a case in which the Tallahassee Democrat published a summarized transcript of the defendant's confession before his trial. I think Your Honor got to this a little bit in your questioning of the defense, but Oliver's not applicable here because there is no confession here. If there's a confession of Donna Adelson, could someone please send it to me? So hence the confession of Donna Adelson has not been published. They cite the testimony of co-defendants, Magbanwa and Rivera, which one is not the same thing as publishing her confession as Oliver, as what happened in Oliver. And also neither of these witnesses really offer testimony tantamount to a confession, Donna Adelson, which I think Your Honor pointed out. In addition, it should be noted that the Oliver case happened in 1968. Another factor Your Honor mentioned in your questioning of the defense, several of their cases happened quite a long time ago. The population of Tallahassee, according to Google, not very official source, was 68,000 in 1968. And when I'm guessing that the Tallahassee Democrat, no offense to my friends, was probably reaching a higher percentage of the community than they do today because of how many options we have today, how much media is out there, and the ways it has to reach us through our phones and otherwise. Today, as evidenced by inquiries of hundreds of prospective jurors in the last 3 related trials, as evidenced on State 1, many jurors abstain from local media entirely, choosing to get news online or from national outlets. An option that was just not available in 1968, or they, some of them abstain from news entirely. Say, I don't watch the news. All right, so all the analytics provided by the defense presume that all the prospective jurors have had equal opportunities to review these stories, and that's simply not the case. Not all prospective jurors consume media the same way. They don't all watch any media that has anything to do with this case, and they certainly don't all do it with the same amount of thought or attention. All of this is fair game for exploration at jury selection and should be attempted before taking this case out of Leon County. There is reference. I thought we'd get more into it with the expert. We really didn't get there, but in the motion, there's some sort of, there's subliminal mind control that the media does on us, which we don't really know. We can't really report at jury selection, but we might be biased and not be able to spit it out at jury selection. So to that, I would say until somebody comes up with a better system, we should stick with the one that's worked for over 200 years, which is the best we have, which is to ask them and rely on their statements under oath about their inner thoughts and feelings. I mean, if we have to read their mind to know what they're really thinking, they could be thinking a lot of things that could potentially disqualify them as jurors, not just related to guilt or innocence, but lots of other biases. So we obviously don't have a crystal ball. We don't have the ability to do that. And until we do, all we can do is ask them and rely on them, which I observe jurors to take their oath seriously and to report as well as they can their inner thoughts and feelings on the subjects that we're inquiring about. The defendant's motion concludes with a citation from a concurring opinion in the Irvin case about the inability of a juror to set aside information that has saturated the media. Here again, this statement was authored in 1961 when it was possible for a media outlet to permeate a community in a way that is no longer possible. Irvin is, of course, still good law, as are all of these old cases that we're talking about. But as Your Honor pointed out, it's your decision it's within your discretion to make a decision based on the circumstances of this case that are present today, which are significantly different from 1961, in which very few women sat on juries because they were only eligible if they voluntarily registered with the clerk, expressing a desire to be placed on a jury list. That's how we did jury selection in 1961. How many volunteers do you think we get if we ran jury selection in that manner for everyone?
Things have changed. Time moves on.
In addition, in the Irvin case, that took place in Gibson County, Indiana, Population 30,000 back in 1961. Again, very different from the demographics that we have here and the population we have to choose from here. One consideration suggested by the Rollins Court is whether the media coverage in this case has been particularly inflammatory. And I mentioned that. I think the podcast could potentially rise to that level, and we certainly should inquire of the jurors whether they have been exposed to things like that. But on page 7 of her own motion, the defendant offers 12 bullet points of what she presumably considers to be the more inflammatory local headlines, none of which are particularly unusual, and only 2 of which mention her specifically by name. The motion goes on to state that her name and image could evolve into an unconscious negative conditioned stimulus when associated with words such as murder. And we digress there into an absurd result where the media can no longer report who in the community has been arrested for murder without creating a unconscious negative unconditioned stimulus such that, you know, nobody who reads that newspaper can participate in jury duty. In conclusion, today's media landscape is a smorgasbord of opinion, news, fake news, and everything in between. For better or worse, most of us navigate that information jungle to seek out, or at least train the algorithm to feed us the stuff we want to see, the stuff we want to consume, rather than being fed, you know, in 1961 in Indiana, what the editor of the local newspaper wanted us to learn. I mean, I get golden retriever videos. I've probably gotten 367 golden retriever videos, and I certainly couldn't recite 80% of them, for your honor, if a gun was to my head. As evidenced by the prior jury selections and the related trials in this case, there just aren't that many jurors that are saturated with local media anymore. Just because the local media is churning out a lot of material doesn't mean that our jurors are consuming or retaining or forming opinions based on that material. There is a local community interest in seeing justice to be served in this case, and there's not a legal basis to move it. The jurors that have been exposed will be appropriately questioned and stricken based on their answers, but it is a bedrock principle of American criminal law to try the case in the jurisdiction where the crime occurred. The defendant has failed to show that Leon County is inherently prejudiced against her, and as such, the state asks that you deny the motion, proceed to jury selection here in Leon County.
Well, as to relief that you're asking for, is it possible also for the court to reserve ruling and still have the jury selection?
You asking me?
I'm asking you.
I think so, Judge. I think you might have to readdress it if you attempt to pick a jury and cannot seat an unbiased jury in this case.
Mr. Zellman, any response?
Yes, Your Honor. First, Your Honor asked the state some questions about the jury selection in Mr. Charlie Adelson's case.
What was the breakdown of no knowledge, some knowledge, or could set knowledge aside for who was picked?
So I'm reviewing Mr. Charles Adelson's initial brief on appeal. Hey,
Joel, I've got to run.
That there were
All right, Tim, thank you very
130
much.
potential
Bye,
jurors
Joe.
that were interviewed on an individual basis. Of those, 96 had heard about the case. Of those 96, 53 believed that he was guilty. I
Those
believe
persons were never actually selected to serve on the
Right.
jury.
correct. The brief does not give a breakdown of
Who was actually selected?
correct. Now, I will say, Your Honor, that Your Honor will recall that there was one potential juror who claimed a lack of knowledge about the case. And in fact, that individual had posted negative.
I recall who. He was also shown the door.
Yes.
Therein, what is the prejudice?
Well, that just begs the question. Does that mean that anytime you have a case such as this, you have to hire a consultant such as the one that Charles Adelson hired so that you can get that information and be able to present it to the court? I don't think that that is the way that we should look at things, Your Honor. Now, in response to the state's other arguments, the state has presented no evidence to contradict the studies that are cited in the defense memorandum. Historically, courts have attempted to mitigate the impact of pretrial publicity by conducting that individual voir dire. Unfortunately, the research concludes that that type of attempt to mitigate pretrial publicity is ineffective. Although I recognize that that is the approved, the courts historically have approved that method. However, the psychological research that is identified in the memorandum all stand for the proposition that that's just not how things work with the human brain. Just because somebody asks you, have you seen an article about Professor Markel's murder? Have you read any of the articles concerning Mrs. Adelson's alleged involvement? Have you formed an opinion? Unless you call somebody's attention to the specific article, it might not trigger that memory. That's what the research shows.
Before you go on that point, and I think in that way, this is where the constitutions have the interplay with each other. Obviously, Florida can offer more procedure or process than what the federal constitution requires.
Yes, sir.
As federal juries are selected, the judge essentially drives the process, questions of inquiry. Does not the Florida procedure give you more rights and more ability in terms of how that jury is selected to drill into those issues of bias?
Yes, Your Honor. I'm not going to comment further, but yes, Your Honor. The procedure in Florida does give us more protections than if we were trying this case in federal court.
So between a pre-screening and then also a full questioning, you still believe that bias cannot be ferreted out?
Given the way that the human brain works, I do believe that, Your Honor. I will say, Your Honor, and this is contained in a footnote in my memorandum, if the court, it's footnote 3, if the court decides to defer ruling or to deny the motion, the defense would request additional peremptory challenges as was approved by the court in Hoy.
Very well. I will review all of the exhibits that were admitted as a part of the hearing today that I was not able to do so prior to the hearing. I believe the jury selections for McBanawa and Charles Adelson are the state's exhibits. The charts and graphs that previously were updated or I did not have access to. A written ruling will be issued. We are in recess.
Your Honor, can we reserve to file a supplemental affidavit to address the concern that Your Honor raised at the beginning of the hearing?
You may.
Thank you very much, Your Honor.
There you have it. It was 2 hours. It was slated to be 2.5 hours, and it was about 2 hours and 47 minutes.
Sure.
Oh, I muted myself. Sorry. Donna. You can see Donna in the orange jumpsuit. I'm not sure if Harvey showed up. I don't know if anyone knows. She's walking slowly.
Doesn't she have ankles?
Yeah, she has. Yeah, she has the ankle shackles on.
Mm-hmm.
So Joe Potuto, I mean, just your thoughts. It's been a long morning. I was saying that they went 2 hours. They allotted 2 hours and 30 minutes. They went 2 hours, 48 minutes, 45 seconds. So they actually used a little bit more time than we expected. And I've got to say, Joe, as expected, Judge Everett seeming just as fair as ever to both sides. It doesn't appear that these motions to have him recused has him acting bitter in any way. He was joking. He was amiable and nice and considerate to both sides. But your final thoughts here.
Yeah, I had a couple of little ones and then a bigger one. One of them was the expert said that his company takes raw data, collects it, and then categorizes it. And my thought to myself was they should hire him to get those 100,000 emails in some sort of order so that they can look at them.
Yeah.
But and the other smaller comment I have is, this rule that you have to try to sit the jury first is not unique to Florida. I know for certain it's the way that this is handled in many states, and I suspect that all states do it that way. That most issues in law have to be concrete. You don't decide on the basis of conjecture or what may happen. You decide on a record that it will happen, and there's a fairly good likelihood that it will happen, or that you can't do it, and now you've proved it 100% that has happened. But this doing it ahead of time is not the way courts work. What Josh Zellman was talking about, and the language of the cases that he cited is right, that between the defendant's right to a fair trial and the inconvenience to the state in a change of venue, the defendant has to prevail. But he was taking that language from cases in which they tried to sit a jury and couldn't, and trying to apply it to a case in which they have not yet demonstrated that they can't sit a jury.
Good point. Good point.
So the language doesn't really, it doesn't really fit there. As I said a moment ago, well, I said earlier when we were looking at this, that the experts' data are all output, not input, and input is asking the jurors. And he admitted that, he helped the state with that. So I can't, and the reason why the judge is reserving is because you're going to reserve on this motion until you try to sit the jury. That has to be right. He can't make a final decision now, no, and then they find they can't sit a jury that they think is impartial, and he still says we're going to hear it in Tallahassee. That's impossible. So it's got to be a decision that has to wait, the time when they try to sit a jury. I thought Georgia's presentation was terrific. I thought she hit every one of the important points, at least that I saw, and she did it in a really professional way, and it was organized and it was clear. And what she does very well, and what it would be helpful for all lawyers to do, is she admits, she doesn't fight everything. She admits where the evidence might be the other way. She said, yes, there's been a lot of publicity here. She didn't get up here and say, no, there hasn't been enough to matter. And that's always a much more effective argument. You have more credibility if you do it that way. So go ahead.
No, I was going to say, at the end there, she also said, look, this is a situation that if you bring the jurors in and you voir dire them and you can't figure it out, then maybe you do have to move it.
Right.
So she conceded that.
Right. She just does a really good job doing that, which is why she has, I think, has a lot of credibility, with the judge. So those are my, I think they're going to try to sit a jury. I don't think the change of venue is going to be granted now. I would be extraordinarily surprised if it's granted now.
But
we'll
he
see
still
when
has
we-
to. He still has to issue a ruling fairly soon, and in
He
that
reserved.
Yeah.
He reserved.
But I'm saying he'll have. The ruling wasn't his comment, which was or George's comment, which is, you've got to try to do a jury voir dire. He's going to say something prior to he's going to have to issue a ruling prior to the trial and say, well, if we can't.
I'm not sure. I think, well, he could, I suppose, but I think he could also he said he's reserving.
Uh-huh.
That's what they wrote. He's going to reserve until they try to sit the jury. I mean,
Okay.
that's what that's what he said today. You can put that in writing, but that's what it looks like it's going to be. And that's the right result.
Yeah.
You got to try to sit the jury before, I said this before, the jurisdiction where the crime occurred has had a kind of a tear in the social fabric of their community. And they have a right to be there and to have citizens from their area sit to decide the culpability of the people who are allegedly involved.
Mhm.
That's why, and typically the defendant has a right to be tried in the venue because that's often where the defendant lives. But the community has a right also not to have a trial that is significant, and this one happened to somebody who had an integral role in the community. He was a law professor at one of the major universities, not taken away from them to make the decision. So, I think the community has a right here, and they'll try to sit the jury, and we'll see. I think they'll be able to sit a jury. I'm always amazed at how many people, even on major trials, have never heard anything. I watched an interview of one of the jurors in the Lori Dable trial last
Mhm.
night, and
Mhm.
he said he had no idea that there was this cult murder, that there had been murders, if nothing, he had never heard anything about it.
Yeah.
And was surprised after the guilty verdict when he came out and started seeing stories. Now that case has a lot of publicity. I would be willing to say more than
Yes,
Donna's case. And you have a
definitely more.
juror has not heard anything about it. Not that he had this sort of, he knew something. And he sounded perfectly credible to me. He was just absolutely surprised about what he learned when he walked out of that courtroom. A lot of people are not focused on criminal trials. Many people are not focused generally on, daily news stories.
Yeah.
They're doing other things. So I think they'll be able to sit the jury, but I do think they will wait to sit the jury.
Yeah. Yeah. Mark Lasky asking about the children, but so just to put a little bow on it, again, it was a 2.5 hour plus hearing. We did kind of a very, 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 very impromptu, unorthodox poll, but by my count, it was less than 15 people from Leon County that were in a chat with, at that time, over 3,400 live. So you do the math. That's a very, very small percentage.
Yeah.
So, that's just, it is what it is. So these were the two hearings this week. I don't know if did you hear them? Is there another one scheduled that we know of, Joe?
I don't know of another one that's scheduled
Yeah.
yet, at least. The defense said, I think there's at least maybe another motion in limine that hasn't been heard, but Josh Zellman said the other day that they're going to be filing at least one more.
Okay.
So once that's filed, there may be another hearing on the last, whatever it is of the motions in limine that are coming up. I did think that he took a dig. It was not a direct dig, but a dig at Dan Roshbaum.
How
Because he had,
so?
well, he had that comment about all the publicity, and he made some comment about prior counsel and that they're now making motions to keep that evidence out. And that was a reference back to, I mean, it was, it wasn't direct, but it was but if you can infer from that he thinks those motions should have been made in Charlie's trial or before Charlie's trial, and it might, and in this context, it might have affected how much pretrial publicity or how much information about the trial would have been in the public domain now. And that was the comment he made, and it definitely was going to Dan Roshbaum.
Yeah. By the way, they were able to seat, although the federal judge picks the jurors, but they seated a jury in the Diddy trial. So,
Right.
and I'm going to be in New York City. I'm going to be back on that within the hour to update everybody.
Hey, Joe, that does remind me of something that was said at the end that I think maybe some of the viewers may have a question about, and that is there was the argument at the end that Josh Zellman agreed to that Florida has more protection in terms of sitting a jury than the federal Constitution requires. What they're talking about is among other things, in Florida, the lawyers do a voir dire. There are states where the judge does all the questions and the lawyer has no input, and that, obviously meets constitutional standards. Otherwise, you couldn't have that. So that comment about Florida providing more, in large part went to the voir dire and the fact that the lawyers ask the questions, and pretty much control, um, uh, what they want to know from each juror, and they get to ask more questions than a judge would typically ask. They can get more particular, more focused.
Yeah.
So
I agree with Tally Gal. I love Joe's brilliant mind. TD, Joe's the best. Um,
well, thank you,
STS
and
is
thank
going.
you.
Yeah, STS will be in Tallahassee for this trial, no doubt about that. By the way, we did a Brian Koberger show last night and
Yeah, I saw
caught
that.
everybody up on that. If you want to check it out, please hit the like button on the way out. Subscribe. Those likes help us quite a bit. We've got a Patreon page. Joe Potuto, I don't know. I owe you an Italian dinner in New Jersey at some point, and maybe more. So I appreciate you
Well,
being
thank
here.
you.
Yeah, we'll get you
Oh,
back on.
thank you, but I also, I find looking at these interesting. And in fact, for quite a while, I was willing to listen to the expert tell me how he did what he did. And then I started thinking, you want to do enough of that for the jury so that they kind of respect what the expert is going to say, even if they don't understand a word of it. But there was a point at which, well, I thought, the jury's just going to tune out. And maybe some of them will say he's so brilliant, I can't follow him. But there are probably going to be one or two others at least that say what I said when it was going on. What he's telling you is they're going to count the hits,
Yeah.
So
Well,
anyway,
I guess the
thank
guy
you.
who profited the most is Murphy, the guy, the expert that was getting paid $29K for his work today. So, but thanks again to Joe. Thanks to Tim Jansen. Read Tim's. He's got a piece in the Tallahassee Democrat today comparing this to Koberger, which it's really apples to oranges. But we'll see you in about an hour, and I'll give you an update on Sean Diddy Combs, including the fact that Kanye West showed up at the trial to support him. And by the way, yesterday, Jane, thank you, Mark. I appreciate that very much. And San Francisco Giants, I guess they're the closest team to Australia. Yesterday in the Diddy trial, Jane, a former influencer / girlfriend, testified that another rapper and his girlfriend, fiance / wife were doing the same sort of freak offs as Sean Diddy Combs, and it's been reported today that other rapper is Kanye. So maybe that's why Kanye showed up. So that's an interesting development, and what a crazy world.
Well,
Joe?
you wonder about some of what goes on in the entertainment industry. I mean, some of these things may happen all over, but it does seem to hit, at least the stories we see, with more impact, among those circles. And maybe that's an unfair thing to say, but it's my observation.
Potuto, I'm glad you and I are not hip hop stars. It's not a world I want to be a part of. But maybe
Well,
in
it's
our
not a
next
world
lifetime.
anybody would come and see if I were doing it, believe me.
All right, love you, America. Love
right.
you, New Jersey, and of course, Tallahassee. Justice for Dan Markel. See you in about an hour.